Good morning, good morning, good morning. It's Wednesday, it's August 13th, 2025. We are getting ready for the trial of Donna Adelson. She is slated to go to trial August 19th. That's the beginning of jury selection, and the judge has set aside 3 days for jury selection. I don't question the court, but I just wonder with Donna Adelson if it's going to take a little more than 3 days to pick a jury. But I don't question the court. Look, we will see what happens. So Donna's set to start jury selection August 19th. The state is set to start their case in chief August 25th. We are going to do a road so far if you are new to this case. This case is not new, but if you are new to this case, we are going to do a road so far. We're going to talk about kind of what led up to this. We'll talk briefly about the prosecutions that came before, because there have been numerous prosecutions in this homicide that have happened prior to this. And then we're going to go to court for the final pretrial hearing that happened while I was on the road to DCI. So we're going to talk all about it and see what we learn about Donna. For those of you that are new, do not worry. Do not worry. I've got you. You know what else I've got? I've got a fresh cappuccino. And this morning I have a fresh made chocolate croissant. We're going to talk about these in just a minute because we have a sponsor, an incredible sponsor with Wildgrain. I was actually on the phone with Judge Abby this morning on her way to court. We now just are commute buddies because our mornings line up. So she was on her way to court this morning and we were chatting a little bit, and most of our conversation was about what we had gotten recently from Wildgrain, because Judge Abby is completely gluten-free. I will eat gluten-free things and very much enjoy them, but it is not a necessary requirement, where for Judge Abby, it is a necessary requirement. So we were chatting about all the glorious things with Wildgrain and some of the things she had tried and some of the things I had tried, and what was in my freezer was in her freezer. I don't know why. This morning we were inventorying our freezers. It was lovely. So yeah, the croissant is absolutely what we're having this morning. So we're going to roll the intro. Let me know where you're coming in from, what you are eating, drinking. I love you guys. You guys are like, I am gluten-free. I am gluten-full. So yes, and gluten-free is one of those things that is hard to do right. And Wildgrain gets the gluten-free pastas, cookies, croissants, and gets it right. So we are going to do a road so far. We're going to go to court. We are going to see what's going on with Donna Adelson. I'm going to eat my croissant while we are in court. Emily, do you just get to snack in court? We do. We get to snack in court. But no, when you're in court, you don't get to snack in court. And we get to start court whenever we want today. We get to just roll with it. It's fantastic. So let's roll the intro and let's talk about Donna Adelson. Look, you guys, there are defendants that we know more about than others. We know more about this case than some of the cases I've covered in trial. And Donna has some interesting legal arguments, but a long road to trial. And I don't have warm feelings for this defendant. Some defendants are more challenging than others, but Donna's going to get a fair trial. We're going to watch the trial. We're going to see the testimony against her. I'm just putting money on she's testifying to all of the things, and she's going to cry. She's going to try to make the jury feel sorry for her. I don't think that's going to happen. So Donna. We need to talk about it, because you're going to trial for murder in just a few days. Less than 5 days? Yeah, we got to talk about it. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. All right, let's talk about this real quick. I pulled up my notes because I want to make sure I don't miss anything. Some of you might have watched the other trials in this case, including Donna Adelson's son, Charlie Adelson. Don't worry, guys. If you're like, Emily, we need a string. Team Baker's putting it together. Team Baker's putting it together. We're going to have a whole case brief for you guys. So if you're like, I'm going to need another one, don't worry, we've got you. We're going to put together a case brief with all of this information so you can see who's connected to who. The victim in this case is Dan Markel. If you watch Lawyer You Know, particularly, you will hear about the connection to the law school where Lawyer You Know went to law school, where Dan Markel was a professor. Dan was a lawyer and beloved legal professor. And he was in the middle of a child custody battle with his ex, Wendy Adelson, daughter of Donna Adelson. And Wendy Adelson, Dan Markel had 2 kids, were getting divorced, were fighting over custody. The prosecution alleges that Donna very much didn't want to be in Tallahassee, wanted to be down in Miami. And it seems that Miami has attitude about Tallahassee. Emily, are you a Florida girl? No, I don't know. I drive through and get on a Disney cruise. That's my experience with Florida. Humidity and I are not besties. So I've been to Disney World. This is my experience with Florida. There are people I like that are there and I go see them. So it seemed that, according to the prosecution, Donna really didn't want Wendy to be with the kids in Tallahassee. Wendy and the kids down in Miami. So the prosecution's alleging that Donna agreed and wanted the kids down in Miami. But as we are leading up in time to the murder of Dan Markel, there were family court hearings going on over custody that were not going well for Wendy to be able to have the kids in Miami because of the shared custody in Tallahassee. Again, Florida, big state, that I get in California. In Tennessee, there's most parts of the state you can get to in just a handful of hours and maybe one stop at Buc-ee's. Florida, not the same. So moving the kids from Tallahassee, where their father lived, down to Florida was not what the court was inclined to do. So Wendy, at that point, was on the losing end of the custody case with being able to move the kids. And the state is alleging that Donna Adelson, mother to Wendy, ex-mother-in-law to Dan Markel, her son, Charlie Adelson, brother to Wendy, cooked up a plot to just resolve the issue, because it seems that the state is alleging if there was no father to visit, then the court can't force the custody. So the state is alleging that Charlie Adelson, Donna Adelson, conspired together to commit the murder of Dan Markel, which was carried out by 2 gunmen who have already been prosecuted. Well, one pled. 2 gunmen and a middleman. The middleman, woman, but middle person, the deal maker, the go-between, who connected the gunman to Charlie Adelson. This individual worked at Charlie's dental office. We're expecting her to testify in this trial. She's already been convicted after trial, 2 trials, but we'll get into the details of that if you want to. This all happened in 2014. So when this goes to trial, we are looking at a trial over a 2014 murder. The government has gone to trial on this piece by piece. So each individual has been tried separately and charged after the others. So Donna is the last one to be charged. Wendy has never been charged. Wendy has always testified at trial. Charlie Adelson will probably testify at trial. He testified at his own trial. Donna will probably testify. Donna is alleged to have handed over the money wet, because she laundered it. And there's a really suspicious jail call between Donna and Charlie that indicates that she has a plan A and a plan B, and she's going to flee the country. And she was arrested at Miami International Airport with a one-way ticket. But her attorneys are saying that wasn't flight. She was just going on a vacation. She was fully intending to come back. So with all of that, we are going to go to court, and this morning's breakfast is brought to you by Wildgrain. So I'm going to share that with you now, and then we are all going to head to court together. A huge thank you to today's stream sponsor, Wildgrain, who just personally supplies all of my favorite things in my freezer. And if you're anything like me, when the days get busy, it's still nice to have something delicious, fresh out of the oven without deciding what to make, finding a recipe, and then having to clean everything up. And that's exactly what Wildgrain delivers right to your door and fresh out of your oven. Wildgrain ships you a fully customizable box of incredible artisanal pastas, breads, slow fermented sourdough, and more. Do not sleep on the pasta, because one of my go-to dinners is the ravioli from Wildgrain. It is so incredibly good. Plus, Wildgrain supports small bakeries all over the country, and for every order, they donate meals to the Greater Boston Food Bank and other organizations. And one of the things I love most about Wildgrain is you don't have to bake everything at once. So even though you get a glorious pack of cookies, it's lovely to be able to take out just a couple for the family and just have fresh from the oven cookies that evening. Freezer to oven, less than 25 minutes. So if you're ready to check out Wildgrain, be sure to hit the link in the description and use code LAWNERD to get $30 off your first box plus free croissants for life. That's right, $30 off plus free croissants in all your future boxes. A huge thank you to Wildgrain for sponsoring this episode and all of my breakfasts, especially when I'm in trial. Let's get back to today's episode. Y'all know that I bring my croissants onto stream. I just, you know what happens. For the 4 of you in the chat that are like, I'm sorry, I'm keto. Don't apologize to me. I'm sorry. Apologies. Because they are delicious and we're going to just sit here and munch together. So I really do. I pull one out of the pack at a time and make them one at a time. The biggest mistake I made the first box of Wildgrain I got was I made all the cookies at once, and the cookies are large. And I was like, oh, I would rather have warm cookies a couple nights in a row than making them in advance. And that is the number one thing I switched, was like, okay, we'll just pull out, who wants a cookie this evening? We'll just pull out one. So Linda D said, EDB, will you be streaming the trial? Did I bring enough for the whole class? Hold on, I'm holding on to that one. I have a code for the whole class, but I cannot pass them through the screen. I can pass the code. Linda D said, EDB, will you be streaming the trial? That's the goal. So the goal is to stream the trial. We've got one travel day in there that might get a little sus, but it's going to be fine. So we're going to go to court. Donna Adelson is in court. There's a lot of legal that happened in between everything that we're not covering today. So we'll get to that in the case brief. So let us go to court, shall we? It is court time. Let me put up our banner, pull up the hearing. The Alpha Beta Omega said, when is the trial happening? Jury selection starts next week. So we will be watching the trial. There will be one day that will be a little sketch because of travel. Jury selection starts next week. I don't know if we'll have opening statements next week. We may not. Jury selection, the court has slated for 3 days next week. I think it could take longer because of how many trials there have been in this. People might know about this case, but the prosecution's case is supposed to start on Monday, the 25th. So either opening statements are the 25th or the prosecution's first witnesses are the 25th. Opening statements could be the 21st, but there is no court Friday, the 22nd. So that's where we're at. So with all of that, let us go to court. They have deep fried microphones. Deep fried microphones. We're going to do our best. There's closed captioning. I'm going to stop complaining. I'm going to let you know. Because deep fried microphones. This hearing is from last week when I was driving to Indy. So we're going to catch up with it now. The Lauren said, how long is trial supposed to be? The longest estimate I have seen is 12 days total. So it's maybe 6 days for the prosecution, maybe 4 to 6 days. So we will see. All right. Let us go. To court. Oh, we didn't fly. Hold on. We've been in Boston for so long. We do need to go to Tallahassee. We do need to go to Tallahassee. Oh, one other statement on all of that before we get to Donna laughing with her lawyers in court. There are a few motions that we have not covered yet. If they are mentioned in today's hearing, I will pull them up because I have them pulled up. So there are a few things that are pending. The defense did make a motion to change venue. This is the one asterisk on this case. Like, the defense made a motion to change venue, and the judge did the thing I think is the most proper and said, we will start picking a jury. And if we cannot get jury people reasonably, if every jury person comes into court and is like, isn't that Donna Adelson the murderer? Fuck her. Then they will consider changing venue. But if a bunch of jurors come in and are like, who? Then they're not going to change venue. So the court is going to wait until jury selection begins to see if change of venue might be necessary. If change of venue happens, it's going to delay the trial. I don't think that's going to happen. They have found jurors for every other trial. This murder was in 2014. We are well and far apart from it. Charlie's trial happened, almost 2 years ago? So I think they're going to be able to find jurors. But that's the one caveat. Though this trial has had numerous false starts where it's supposed to start trial and then shit comes off the rails. So who knows? Music to My Soul said that seems like the logical approach to me. Same. It happens. Same. Other courts have decided this earlier, but generally you wait to see if there are truly jurors that say that they know about the case. All right. Now back to court. Bring the judge. Bring the judge. And let's go to court for the final pretrial hearing for Donna Adelson, facing charges for murder, conspiracy to commit murder. Oh boy. And yes.
All right. Court is now set and the Honorable Judge Stephen Everett presiding.
I really like Judge Everett a lot.
Morning, you see it?
Hi, Judge.
I like Judge Everett. Judge Everett's like, okay, it'll be fine. Also, thank you to Team Baker Production, Team Miguelina for doing her best to take care of the sound and taking out all the long pauses so we don't have to zoom. Thank you. Thank you.
Here this morning in State versus Donna Adelson, 2023 CF 3226.
This is our
For the final pretrial hearing
better
this
audio.
morning,
deep fried
we're
microphone.
going to address all of the outstanding motions and also some matters pertaining to the trial, which is still scheduled for the selection of the jury starting on August 19th. The parties can make their appearances for the record.
Georgia Kappelman for the state.
Jackie Fulford for Mrs. Adelson.
Joshua Zellman for Mrs. Adelson.
And yes, for those of you asking, these are Donna Adelson's new attorneys. These are not the attorneys that represented his son in his trial. The attorneys that represented Charlie Adelson in his trial were yeeted the day of jury selection in September 2024.
I believe we have several defense motions to address. Ms.
Yes.
Kappelman, the state has not filed any additional motions in limine that have not already been addressed by the court.
That's correct, Your Honor.
Right.
Motions.
Let's start then with the motion in limine concerning the court file relating to the dissolution of marriage.
So the court is going to take up the motion in limine regarding dissolution of marriage, which is the divorce of Wendy Adelson and Dan Markell, the victim. Remember, it becomes highly relevant what was going on in that divorce and the proceedings that were happening, because the proceedings that were happening play into whether or not there was motive. And so with that, how much of the prior court proceeding comes in, and part of it is how much did Donna know?
Mr. Zellman?
Thank you, Your Honor. Your Honor, as is my custom, I lay it out in motion.
His motions are pretty short.
That the vast majority of the court file, even with the court taking judicial notice, is inadmissible. It's irrelevant. Paragraph 7 of my motion
It's highly
provides
relevant.
a somewhat comprehensive list of the items that are in there that have no bearing, have no relevance. They're not material in any way to this case. And so we're asking that, aside from very limited number of items that the statement established has relevance, and it's not barred by hearsay, we're asking the court exclude that file.
Ms. Kappelman, which parts of this file is the state seeking to admit as a part of its case in chief?
The entirety.
Right.
The defense, Your Honor, there's just a few little things. There's just a few little things that are relevant. The prosecutor, all of it, all, total, full stop, all of it. We want all of it. This prosecutor has been the prosecutor on all of these cases. So the prosecution is just like, okay, we're just going to keep doing it. I'm living for the purple suit. I'm also living for the full just
mention it all. Mention it all.
Mm-hmm.
As to the items that deal with, as identified in paragraph 7 of the motion, what exactly would be the relevance first? And what is your argument as to hearsay?
For relevance, Judge, it goes to the motive, the level of intensity of this litigation, the volume of the paperwork suggests that it was very litigious and went on for some time. The words that are used are strong, even hateful, and this was a cause that was adopted by the defendant, as the emails evidence will show. So it's important for the jury to understand the foundation of this motive is this litigation that began with the divorce, continued beyond the divorce with the child custody issues that developed later.
All right. So in part, the volume of what occurred over the divorce proceedings, you want the jury to recognize this goes to motive in some way.
Yes, Your Honor. In reference to hearsay, the items are not being offered for the truth of the matter asserted. There obviously was a litigious divorce, but it's being offered to show the effect on Ms. Adelson. These items were shared with her. The evidence intends to show she was very involved in the pleadings. She was sent the pleadings and offered detailed responses for how Mrs. Wendy Adelson should respond to the pleadings. So it's very bound up in the state's theory of the motive for the case.
Motive.
Right. Mr. Zellman, as to your client's emails to her daughter as this litigation was going on, are these contested in any way?
So there are emails that reference back to the litigation. So the emails prove that Donna Adelson had knowledge. The file's not being offered for the truth of the matter asserted. So that's why the prosecution's saying this is not hearsay, because it's being offered to show motive. It's not being offered to show the truth of what was happening in the family court. It's being offered to show what Donna knew and what the emails mean.
Back to the initial dissolution proceeding, no. However, in reviewing the emails, the post-dissolution matters that were filed by Mr. Markell, there's no evidence in those emails that those pleadings were shared with Mrs. Adelson. And so certainly, if the state's theory is that it goes to the motive, and that's the way of getting around hearsay, they have to establish that the pleadings were sent to her. My review of the emails show that did not happen. So they can't go to show my client's motive if
I don't know why there's a train driving through the courtroom. I can hear it on the audio. I just can't see it on the screen. I don't know. The defense is saying, look, you've got to prove if you're using it for motive, you have to prove she knew.
she didn't receive that.
Right, as to any pleadings that correspond with emails or communications that were made by the defendant and otherwise demonstrate her role in or some part in the divorce case, as to those, I'm going to rule they are admissible. The pleadings themselves, if they're being on.
So the court said the emails and the pleadings that correspond directly to emails are admissible. So if there's an email talking about a particular pleading, then that pleading becomes admissible. That's where the court is.
Or communications that were made by the defendant and otherwise demonstrate her role in or some part in the divorce case, as to those, I'm going to rule they are admissible. The pleadings themselves, if they're being offered not for the truth of the matter asserted, but to otherwise demonstrate motive or intent, those are admissible. However, Ms. Kappelman, as to the bulk of the file itself, I do believe the defense is raising a clear point on this. Absent a connection or a nexus between the defendant and specific aspects of the divorce file, what is your argument concerning it?
There are pleadings in there.
So the court is saying, with regard to the things that don't have a nexus back to Donna, what is the argument? Because for it to be part of Donna's motive, she has to know about it. It can't be motive if she didn't know. So the court is saying, what's your argument? How do you prove some of the rest of the file? Because the court's already said this list of things is coming in. And the court's well familiar with this from doing the other trials. But outside of that, how do we know it's coming in? But yes, for all of you who are like, these are Charlie Brown teacher microphones, yes.
There that are not necessary to show the motive, but I did offer the exhibit itself in its entirety to demonstrate the bulk. If Your Honor is not inclined to allow those pieces of paper that cannot be directly connected to the defendant, may I be permitted to show the exhibit as a demonstrative to the witness to verify that that is the entirety of the divorce file?
It is permitted as a demonstrative. You may also ask questions that.
And I'm going to pause a bit and rephrase just because the microphones are so hard. The prosecution said, look, I want to show the volume of how litigious and contentious this divorce is. So even if each filing in that file doesn't come in as evidence for the jury to read or look at, I want to show how voluminous the file is so that the jury understands that this was not going smoothly, that this is a highly contentious, highly litigious divorce. And the court said, yeah, you can use it as a demonstrative with the witness to show the divorce file was substantial.
Generally deal with the amount of filings and also the volume of the case, but ultimately as to responses for production or mediator notices, I'm inclined to agree with defense as to that point.
Right.
If there's not either a relevant connection or a nexus between the defendant's actions and then what occurred in the dissolution of marriage case, all of it does not come in as substantive evidence. But I do want to make clear on this point, Mr. Zellman, as to what the witnesses will testify to, and none of us know this until the evidence actually begins. This file can be used for purposes of impeachment, and it can also be used for purposes of rebuttal. Depending on what the witnesses say, what might be not a part of the state's case in chief may still be available to them through other means.
The court is reminding the defense, look, Every single piece of paper in that file is not coming in as evidence. The entirety of the file can be shown as a demonstrative. However, it can be used as impeachment of Wendy, of Charlie, of Donna. It can be used as impeachment, which means if somebody says something that contradicts what's in the file, that thing in the file now comes in or can come in. And he goes, and there are other means. This does not forestall it coming in. There are other things that can open the door to it coming in. So be aware, I'm not keeping it out in its entirety forever because other things might let it in.
Not permitted by the rules of evidence. Is everyone clear on those?
Yes, sir.
Yes, Your Honor.
So it's not a blanket, like this is never coming in. It's a, this may come in through other means depending on what happens in trial.
All right, let's move on to the motion of limine concerning the testimony of Sarah Youssef. Mr. Zellman.
Again, Your Honor.
We are moving into a different motion in limine. The first motion in limine was largely denied, but partially granted. The next motion in limine is regarding certain testimony. So we're getting into the defense's motion regarding that testimony.
We stand on the motion.
Ms. Kappelman responds.
I would just ask Your Honor to reserve on her. The state has no intention of calling her, so I don't think, unless that changes, that there's any reason to address her testimony at this time.
Well, and I assume you are going to leave Ms. Youssef available as a rebuttal witness if necessary.
Yes.
If the witness is not going to be called, that essentially moots the issue. On that point, Mr. Zellman, the state is not committing to calling this witness. If they do call them at that time, I will issue a ruling concerning your motion in limine.
Yes, sir.
As to any purpose of rebuttal, ultimately what comes out as a part of the defense case, Ms. Youssef still is able to testify in that capacity. Right, the next motion of limine concern.
I'm just going to pause for a moment and point out, do we see how smoothly things are going? This motion, the defense is like, we stand on our motion. Great. Prosecution, we don't intend to call this witness except for rebuttal. Great. If you change your mind, we'll rule on the motion then. If this comes in rebuttal, we'll take care of it then. Next motion. So these are all those pre-trial motions to determine what the evidence looks like as we get into trial. Just normal. Motion, motion, motion. All right, continuing on.
The testimony of Stephen Webster.
This is the next motion to
Does the
eliminate.
defense have any argument that has not already been made through the pleading?
No, Your Honor.
Ms. Kappelman responds.
Judge, I agree with some of the defendant's motions. I don't think Mr. Webster can offer opinions. For example, his testimony, of course, will be governed by the same rules of evidence that every other witness is governed by, but he does offer some relevant points. So I think I should be permitted to, I don't know, these motions kind of blow my mind because it's like we want to pre-litigate every statement, including
Yep. That's
potentially objectionable statements that can be addressed during the trial by a proper timely objection. So I would ask that it be handled in that way.
Right, concerning the testimony of Mr. Webster. Mr. Webster, in his capacity of representing the deceased, certainly can testify factually as to what his involvement was with the divorce case. And also, he may testify concerning the nature of the proceedings as to any opinions that go beyond that. Ultimately, I think that's where we are going to have to get into what is being asked and what would be the response.
The court is ruling now that the witness, who is the victim's divorce attorney, can testify to factual things, but can't give an opinion about certain things. And the prosecution said, well, yeah, the rules of evidence apply. The rules of evidence are not simple, but they are finite. And so the rules of evidence apply here. And we will follow the rules of evidence. And the court says, yeah, the attorney can testify. And if there are objectionable questions object.
That ultimately the defense would find objectionable. But generally, as to any opinion that Mr. Webster cannot give without a proper foundation, I think it's settled as a matter of evidence that no witness gets to generally opine on matters in which they are not qualified to testify to. Is any other ruling being sought concerning Mr. Webster beyond that by the defense?
Well, yes, Your Honor. In prior trials and in deposition, Mr. Webster testified about statements made to him by Mr. Markell. Those are hearsay. There's not an exception. Those statements weren't shared with anyone else, certainly not my client. Those were statements that were made during the meeting in May of 2014 that Mr. Webster. There's no exception.
The mics just stopped for a second. Apologies. Not our mics, but they are talking about statements the victim made to his lawyer and saying they are hearsay without exception. We'll hear what the prosecution says.
That I'm aware of under the hearsay rule.
Statements made by the deceased to Mr. Webster. Ms. Kettleman, do you have an argument?
I think I agree in general that those statements would be hearsay. I don't recall what my theory of admissibility was in prior trials, but I would agree to approach if I intend to elicit a statement made by Mr. Markell to his attorney and offer my theory of admissibility prior to asking the question. If I decide to do that in this trial, I don't think
I don't remember what my theory of admissibility was in prior trials. She's like, let me go look at the transcript. What did I argue? I must have done a great job. That must have been amazing. So she's saying, no, I agree. And if I intend to ask something, then I'll approach and ask, but I'm not just going to ask it. I appreciate I agree that those are hearsay. Something must have happened that made them relevant, and it was probably in response to cross.
I plan to do that, so it's hard for me to address what that theory might be now.
Well, again, as a general principle of evidence, hearsay that has no exception is not admissible.
And the court's like, right, rules of evidence.
If the state is seeking to admit this statement for a proper purpose that actually has a basis in the rules of evidence to be admitted, you will need to approach so that way the information is not placed improperly before the jury. The motion in limine is...
So the court's granting the motion in limine. The court's like, right, follow the rules of evidence. If you think there's an exception, approach. And everybody's on the same page. They're like, right.
Granted as to Mr. Webster offering any opinions for which he is not qualified to give, the court will reserve ruling on the issue of any statements that he may testify to by the deceased if the state, again, will have to present an actual exception to hearsay in which the matter can be placed before the jury. Right, the renewed motion in limine concerning the Latin Kings.
The defense has brought a motion in limine regarding the Latin Kings criminal street gang. So that's what we are getting into now. If we need to pull this motion, we'll pull it up. But I'm very interested to hear the defense's argument on this. I saw the filing. I did not go through it. We were going to do it together. I saw the filing. I knew this hearing was there. I have been waiting. I have not been reading about this hearing. I have been waiting to see it. But I've got the motion. But let's hear the argument in court and go through the defense argument regarding the Latin Kings.
Mr. Zellman.
Yes, Your Honor. This goes in part to the theory of the defense and why Mrs. Adelson acted the way she did the language that she used on the 2016 wire calls. Typically,
Ding, 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 ding. This goes to our defense as to why Donna Adelson acted the way that she did and the statements she made on the 2016 wire calls, because there was a wiretap and the things that were said on the tapped line are going to come in. Let us continue.
I know that we would want to have the foundation laid through her testimony for that, but if the court were to bind our...
He's saying all kinds of interesting things. We're going to lay the foundation through her testimony. I'm sorry. Donna Adelson doesn't strike me as a gang expert. I don't think ma'am even watched, I don't know, anything. She tried to launder money in her clothes washer, in her washing machine. Not even like the dishwasher, the clothes washer. Like, she physically washed it with water. So, I don't know if she's qualified to testify about the Latin Kings beyond stereotypes from media. But I'm interested to hear. So, for those of you asking, yeah, I don't even think she watched The Wire. No, not at all. Yes. So when we're talking about The Wire, we are not talking about recorded jail calls. A lot of you have asked. We are not talking about recorded jail calls. We are talking about a wiretapped phone line. In the words of Biggie Small, got my phone tapped in the basement. We are talking about a wiretap where they tap your phone and listen to all of the in and out calls on the wiretap. So these are wiretapped calls, not jail calls. This is before Charlie Adelson was ever arrested, before Charlie Adelson ever went to custody or to trial. I am Ken Ross. Good to see you. Said she washed money. WTF. Yes. And the go-between said that the money was still wet and kind of smelled like moldy, mildewy, musty when she paid the go-between for the hit. Mm-hmm. I mean, at least she did it in cash. She didn't try to use like a American Express points, I guess. Let us continue. Cara D. Hewen said, so Granny's a gangster? No. Granny's a poser. Gangsters would be insulted. Granny's a poser. Granny uses stereotypes in TV and literally washed the money. Let's continue. Yeah, this is not how this works. Not how this works.
Hands in questioning the state's witnesses, it would be too late to wait until she testifies. We would lose the ability to cross the state's witnesses on that issue. It's very limited. You have Luis Rivera. There would only be a few questions at most. Potentially Charlie Adelson, depending on when the state calls him. Certainly Special Agents. I believe it's Jimenez.
Now, in the last trial, he outright testified that he was, I guess, at least pretending or trying to be a member of the Latin Kings gang.
Yes, sir.
So the court said Luis Rivera, one of the gunmen, said in the last trial that he was at least pretending to be a member of the Latin Kings. Don't do that. Also, don't do that. Sir, don't do that. Don't do that, because you're in prison and there are going to be members of the Latin Kings in prison. It's essentially stolen valor. I mean, I don't know what to call it in the gang sense of the word, but I don't have another word for it. But you don't pretend to rep a gang you don't rep. That's not how that works. Oh no, the undercover agent. That's right. Different one. Thank you, chat. The chat's like, no, that's the undercover agent. Sorry, the officer. Yes. Well, cops lie. That's a different issue. Cops lie. Thank you, chat. It's been a minute and I didn't watch Charlie's trial. We might go back and watch Charlie's trial together after we watch Donna's. The Lauren said so they can bring in any previous testimony for impeachment purposes, and there have been multiple trials. Yes. All right, let's continue.
All right. To that end, Ms. Kaplan, what is your argument?
Same as my argument has always been on this issue, Judge, which is that Rivera was a gang member. That's why he was recruited to do this. I think that's relevant. But the fact that he was a leader of a specific gang, I think is just bad character evidence that doesn't lend anything additional, more prejudicial than probative, and I would ask to exclude those details.
Similar to what we had in the last trial, as to this painting character of Mr. Rivera specifically.
Okay, so as to Rivera, the court is saying, hey, we have heard in other trials that he is a gang member. He admits to being a gang member, so that's different. So Rivera, the hitman, I thought they were talking about Rivera. Rivera, the hitman, admitted to being a gang member, and the prosecution is saying, right, but as to his position in the gang and as to his particular gang or the name of his particular gang, that's just character evidence.
And a negative, right? The court's ruling will remain the same. As to the witnesses, though, Mr. Jimenez or other witnesses that may bring up this topic unsolicited on their directs, once the horse is out of the barn, it's out of the barn. As far
Your Honor. Hi. Can we have a chat? Because once the horse is out of the barn, the horse is out of the barn is fair. But what happens when the shit is out of the horse? Also, I love that the court is using once the horse is out of the barn. Once the toothpaste is out of the tube. Once the shit is out of the horse. Look, once the shit's out of the horse, it's not going back in. So I love that the judge's reference is just so aligned. We're just, Your Honor, we're on the same page. I like this judge a lot. Every pretrial hearing I've watched, I'm like, I cannot wait to watch a trial with Judge Everett, because he's just like, this is what we're going to do. It's just, he is so calm and even-handed. So calm and even-handed. So the court has said, look, you can't get into what specific gang he's in. You can't, for Rivera, you can't get into his relative position within the gang. Rivera's not on trial. That's already happened. So it just becomes character evidence to be like, he's a bad guy. I mean, he's already been convicted of murder. So I don't know if you need anything more than that. And it just piles on him, which is not the focus of this trial. He's already had his trial. So the court is saying, look, as to other witnesses, if that horse gets out of the barn, it's already gone. So.
as in cross-examination of Mr. Rivera specifically, the defense may cross-examine Mr. Rivera as to his role as a gang member and why he was recruited into this matter to specifically serve a purpose as it relates to the conspiracy of the killing of Dan Markell. Now, with regard to undercover or the former undercover agent, Ms. Kaplan, this is where I believe the analysis begins to diverge on this topic.
The court said, okay, look, as to Rivera, he's an admitted gang member. You can ask him about a gang member, but not which gang and not his role in the gang. You can't bring that up. And the prosecution was very clear to say he is an admitted gang member. She did not say which gang. He is an admitted gang member. Now they're getting into the topic of the undercover, and the court said this is where the analysis starts to diverge because it's different. Cops are allowed to lie to you. All right, let's keep going.
He specifically approached the defendant as a Latin King member, correct?
No, sir. My recollection is, I know that was his testimony, but and I would instruct him not to say Latin King in the future. However, he didn't say anything to Ms. Adelson.
Do you see the binder the defense is looking at? Just take a moment. Take a moment and look at the binder. When we talk about the fact that there are numerous other trials with testimony, do you see how large that binder is and all the tabs? Because the defense would have tabbed the testimony of each witness from each proceeding. So if we're talking about an undercover officer, the undercover officer may have testified at 4+ trials at this point. So the defense is actually, it looks to me, going directly to the page. They might have some of this digital, but for a lot of lawyers, I'm a lot of lawyers, you have to have a printed copy. I think it's worth talking about this for a moment. Emily's love of paper. When you are in trial, if you only have it digital, it becomes very awkward when the witness says, "Can you show me?" But when you have this giant fucking binder that the defense has that looks very organized and glorious, if a witness says, "Can you show me?" you get to walk that big intimidating binder up. Remember, trial is partly theater. You get to walk that big intimidating binder up to the witness and point where it is on the paper. That has much more impact than being like, "Do you see right here? That binder, I might have as many pages." Probably not yet because the super note is new to me. I might have as many pages. The binder's way more impressive looking. Also, it's probably faster to find things for an attorney that's been doing things this way for 20+ years of a career. And if the witness says, "Can you show me?" you can just unclip the binder and walk it up to them. And you can show them the paper. It also resonates with jurors because you need people to ascertain, it's kind of like advertising. You need people to understand what the thing is quickly. And what you don't need is a juror sitting there going, "Oh, he's showing him something on the computer. Is something on the computer real? Is it not real? Was it altered? Was it modified?" We all know you can print out something that's altered, but it does not trigger that thought process in your mind the same way. So having that big giant binder of shit somebody said in front of the jury's going to be like, "Wow, it's a lot of transcripts." So it's also, for a lot of attorneys, faster. It's just going to be faster to flip to the tab number and be like, "You said it on this day." This is a great point, Crochet Cat Mom. Binders don't crash. Yeah, binders don't crash. Binders don't crash. Binders don't need to be charged. And they need the paper to give to the witness anyway. So that's why they have binders. They would also have it on the computer, but this trial is much more like what I am used to. This is much more like typical state court trial for now, because there's 2 defense attorneys. There is not a fucking fleet of law clerks and attorneys sitting behind them. So you don't have an Elizabeth Little going line page and pulling it up for you. The attorney has to do it in the moment while they're listening. And it's much easier to do that with paper than to be typing into a computer and trying to listen to the court. Angel said binders don't have battery limit or need to have a charger. Kat in the chat said, "My web browser just crashed." As Emily said, binders don't crash. I'm sorry. Something's probably still in retrograde. All right. I love the way this is organized. Yay, attorneys.
About being a Latin King. I guess that was his version of acting like a gang member. I don't know how well he did. Ms. Adelson didn't seem to think he did very well. But that was the intention. He did not represent himself to her verbally as a Latin King gang member. He was not wearing any clothing or other signifiers that he was a member of a specific gang.
Would Donna Adelson even know what the clothing that represents the Latin Kings are? Can we be for real? Come on.
I think the idea was just, you're an associate of this killer who is a gang member.
Any response on that topic, Mr. Zalman?
Just looking at his previous testimony. My role, I'll quote from page 1067 of the trial transcript, Mr. Charlie Adelson's case.
Defense is going to read in testimony from the undercover to, from the undercover in Charlie Adelson's trial. All of you are like, Emily, what does a Latin King wear? I don't know. I didn't deal with the Latin Kings. I was in LA. This was not one of the gangs that I came across frequently. But if we ever want to talk like Crips Bloods and different sets, we can do that a different day. But no, where I prosecuted, Latin Kings did not come up. It was not part of it. Aaron's like rolling 60s. I mean, and 40s and 20s and Grape Street. We could go on, but Los Angeles. So different. Some of you in the chat are saying they tend to wear black and white. I don't know. We can take a look. But yeah. Let's see. Somebody asked, Inside Your Bones said, did you deal with Aryan Brotherhood? Only when we had cases that came out of the prisons. So if something had happened in the prison and it was being prosecuted, yes, but they were not active in shit in the area where I was. I wasn't in Central Cal, but when we had shit coming out of the prisons, yes. But there were other DAs that I worked with who had much more interaction with them. I did not work in hardcore gangs either. So I did not work in a specific gang unit. So I was dealing with lower level gang member shit. And then I dealt with it a lot in juvie. So conversations for another day. All right. Continuing on. Let us go. Heather said my girlfriend in her mid-50s wears black and white. Never knew she was a Latin King. Heather, first of all, your girlfriend and I have the exact same outfit choices. We're just Gen X. Our color palette is gray.
Starting at line 20, question, can you explain what that operation was? Answer, my role in that operation, I was portraying a Latin King gang member and I was instructed to conduct the bump. Continuing on 1060.
Oh, no, he was counsel. No, he was just method. No, counsel, he was just method. That was his character. Your undercover's not testifying that he was telling Donna Adelson that. In his mind, that's where he was like, if I'm going to act like a gangster undercover, I'm going to be a Latin King. And so it was just trying to get into character. He wasn't telling Donna Adelson that. He was just embodying it so he could accurately represent himself. 'Cause undercover. It sounded like he did a bad job though. I want to hear the rest of this testimony. I'll stop making jokes about method acting, but however, I think that's exactly what it was.
Wilson's case. Starting at line 20, question, can you explain what that operation was? Answer, my role in that operation, I was portraying a Latin King gang member and I was instructed to conduct the bump. Continuing on 1068, question is, all right, when you say you were posing as a Latin King gang member, did you announce yourself as a Latin King gang member to the person you approached? I did not. Okay.
Right. I did not.
You're just, that's the role. That was my role. You're in character.
I should have just kept listening. That's the role. I was in character. Vibes.
That is correct. That is his testimony. And
His test, Cal, counsel? Come the fuck on. Did you announce yourself that way? No. So that was your character? Yes.
Yeah, I believe that once, especially with the call that my client made to the undercover on May 6th of 2014, when he became verbally aggressive towards my client, that factors into his role as a Latin King gang member. And I know in the previous hearing last year, Your Honor questioned whether there was a difference between a Latin King gang member and simply a gang member. The answer is absolutely. In Miami, in South Florida, there is absolutely a difference between a gang member and a Latin King gang member.
Even with that being said, this ultimately...
Him saying, I'm channeling my inner Latin King as character to be undercover, if he does not say that to her, how... that might be her perception. She can testify that that was her perception. The problem is, I don't think that was her perception then, based on what happened on the calls. She's mad that she's on wire.
Goes to your client's state of mind, who is going to establish how she knows
Her.
the difference between, forgive the pun, the garden variety gang member and a specific gang member.
I think between her testimony and anticipated testimony of Charlie Adelson.
The court said, who is going to establish what she knew? How does she know this person is this particular type of gang member? Her testimony. Oh, all of you talking about Sons of Anarchy. We can have a whole conversation about my love for Sons of Anarchy. We just can't do it now. I'll get derailed. But how do... Look, sir, Donna washing money over here. I don't trust that Donna can pick out a gang member from a teenager at the mall, first of all, and B, can be like, oh, I know this and this and this and that. So I'd be interested to hear how her testimony is going to go about how she knew which was which. Also, chat, I have derailed. Thank you, mods. I have derailed us to SOA. Emily allows it. Emily, do chat rules go by vibes? When they come to Sons of Anarchy, they do. So Donna Wash the Money Adelson is going to testify and explain how she knows the differences of different gang members, which I'm sure she's learned more about since she's been in jail. The cross-examination. God, I want this prosecutor, and I have not watched this prosecutor in anything other than motions because I didn't watch the other trials. This prosecutor, I need her to come in and be like, ma'am, you thought money laundering went on the gentle cycle. And you're telling me that you know the difference between what? Gangs? Okay. I'm going to need you to explain. I need that cross-examination. I need the cross-examination to happen. Because a criminal mastermind, Miss Donna is not. Let us continue. The court is just like, the court hasn't gotten there yet, but the defense says Donna's going to testify and Charlie's going to testify. Charlie can't testify to what Donna knows.
All right. As to the questioning of the former undercover officer or special agent Jimenez, I will permit the defense to question the former special agent as to whether he is portraying a member of a specific gang as a part of his bump operation. Depending on what the answer is, we will revisit the issue of whether the name Latin Kings needs to be specifically uttered. as to either Mrs. Adelson or Charlie Adelson testifying concerning her state of mind and knowledge of the Latin Kings. As it goes to state of mind, the defense may certainly inquire as to that during the defense case in chief. As to Luis Rivera, the court's ruling.
Is it closed captioning that keeps calling the Latin Kings Aladdin Kings? I didn't notice. However, street rat, not street gang with Aladdin. Also, I don't know if a boo counts as another gang member. I mean, under the laws of Florida, definitely not. I would have to check Agrabah because maybe it seemed the laws, some of them were very aggressive. So I don't know if you could define a boo as a co-conspirator. I have questions. But we'll get there. So the court is like, look, I don't know if we're going to get to specific gang affiliation.
Will remain the same as to his leadership role or specific affiliation. The fact that he is a gang member may be inquired into, and the fact that he has had, or
I do think Jasmine's a co-conspirator for sure.
the fact that he was
100% an accomplice. Mm-hmm. Maybe an accomplice after the fact. Maybe not a co-conspirator because I don't think she agreed to help. She like jumped in the middle. So accomplice after the fact would be more appropriate. We can go through that whole sequence of Aladdin and issue spot if we would like.
while he was recruited in this case, that certainly is ripe for cross-examination and may be inquired into. But as to him being a specific Latin king, that is where the line is going to be drawn. Do we need any clarification on these rulings?
Just a moment, Your Honor.
Not from the state judge.
So I needed to text back my kiddo who has lots of logistics that he has to deal with today.
So the concern
Can we not with the extreme close-up?
we have, Your Honor, is that Mrs. Adelson, part of her state of mind, her level of fear, is that it's not just that she learned he was Latin king, but that he was the leader of one of the branches of the Latin kings in South Florida. That heightened her fear. And of course, she will testify to that.
I cannot make her testify. If she's committed to do so as a part of her defense, that's her choice. But ultimately, someone with competent knowledge has to testify to this fact. Eliciting information about state of mind from the witness that either has not spoken to your client or either has no knowledge of the state of mind, I'm not sure how that can be accomplished other than either your client herself,
Oh, no.
her son, or someone else.
She has to testify about state of mind. Yeah. Donna Adelson's going to testify. In my head, it's like Donna Martin graduates. Donna Martin graduates. Donna Adelson's 100% going to testify. 10.
Who has direct knowledge of her state of mind at the time, unless you have an argument.
So I guess the way that we could accomplish that, Your Honor, is that Mr. Rivera, he is under a defense subpoena. We would ask that he remain for the defense case so that we can call him on our case in chief.
That's fine.
Call Rivera.
Mr. Rivera, as I recall, never had any direct communication with your client, but this is to elicit another relevant matter.
That's correct, Your Honor. It would be once we establish the foundation, I would want to recall him for the specific purpose of him confirming that he was a leader of the Latin Kings.
Very well.
So
Mr.
it's going two ways. So the defense said, look, as to Rivera, who had no contact with Donna Adelson, the court's like, I remember no contact. And again, the court has been on all of these trials, so it's helpful. Has had no contact with them. The defense said, look, once Donna establishes her fear of them, the Latin Kings, or them, Rivera and the other guy and the undercover, then we want to call Rivera back to ask him his position in the gang. And it's going to depend on what Donna testifies to, right?
Remain under the defense's subpoena until the conclusion of the trial. Let's move on to the defendant's motion of limine as to the interpretation of emails, recorded phone calls, and text messages.
Defense motion in limine regarding the interpretation of emails. You can put in an email. There are different circumstances when you would say this email means that. So that's what the court is talking about in the defense motion in limine regarding emails and motions in limine. All right. Next defense motion.
Which witnesses is the defense referring to concerning this motion?
Your Honor, I think it goes really to
Can I make myself smaller so we can see the defendant?
retired Detective Isom, Special Agent Sanford, potentially Jason Newland. I think a number of witnesses have offered interpretation of statements that were made. Now, we're not talking about coded language. Coded language is treated different. What we're talking about is the emails, the recorded phone calls, and the text messages, other than coded language. What we're asking of the court, because it has come out so frequently, that the court prohibit the state and, what's good for the goose is good for the gander, the defense, from asking someone other than an expert to offer an opinion about what someone means by an email, what they meant by a statement, or what they meant in a text message, aside from the language that's used itself.
Ms. Cobbleman, response?
I agree, that would not be admissible.
The motion in limine is granted as previously raised in the argument.
The prosecutor is such a vibe. The prosecutor's like, well, Your Honor, he's just restated the rules of evidence. And under the rules of evidence, that's not admissible. So we're all on the same page. Part of me just wonders if the defense attorney is like, look, Donna, we've got you. Because the motions were pretty short. We've got you. We filed this motion. They can't do it. I wonder if some of this is client communication and client support being like, look, we filed all this motion, so they can't do that. Instead of just saying, look, under the rules of evidence, they can't. It's like, look, no, we filed it, see? And the court's like, right. Under the rules of evidence, you can't do that. Everybody's on the same page. Kristen, yes, thank you, client management. Like, look, we filed it. It's fine. Oh, boy.
On this matter, any matters that would go to a code in which a witness could lay a proper foundation on this issue. Certainly, they may testify as to that point, but any general opining as to what an email, a phone call, or a text message means will not be permitted unless there is a proper foundation that can be laid by that
Right, things
witness.
just go by their plain language, and the jury gets to interpret what it means unless it's coded language. Like, I don't know, if a bunch of people are calling a weapon a certain thing or narcotics a certain thing or whatever, if people are referring to a thing as a certain thing, then you can have someone who's familiar with that come in and explain. Like if you have a junior high school student and all of a sudden they're saying Ohio, you might need someone to explain to you what the fuck Ohio means because it's a state. So you need someone to be like, no. The way they're using it is this. So you need that explanation. So it has to be beyond plain language. And then you can use an explanation for the code word if somebody knows what it means in context. So, so that. Continuing on.
Next, the defendant's renewed motion in limine concerning travel as consciousness of guilt.
Ooh, I was excited about this one. The defense was arguing that Donna Adelson's one-way ticket to Vietnam was not proof of flight. However, there are also recorded phone calls that indicate that she was searching for non-extradition countries. And the defense is like, she was just going on vacation and she wasn't under arrest, so she wasn't fleeing. So I'm very interested to see how this ruling goes. We've talked about this before because this motion has come up a couple times. So flight as consciousness of guilt.
Your Honor, I know that the court has previously ruled on this issue and has, that allowed the state to use this information in their arguments. The new information, as I laid out in paragraphs 4, 5, 6, and 7, I stand on the motion. Those additional pieces of information had not previously been provided to the court, and I think that it's significant because it goes to her state of mind for making the travel plans and for going to the airport and for stepping on her jetway.
She didn't. She stepped onto a jetway and then she stepped into some handcuffs. And then she was like, what is this about? You can't touch me. Don't take my cell phone. Ma'am, we heard your jail calls with your son talking about fleeing the country. When law enforcement approached you, you knew exactly what the fuck it was about. Don't play with me.
And prior counsel's argument correctly, Mr. Rashbaum did raise the fact that there was no legal process, subpoena, or warrant for your client, correct?
I believe that's correct, Your Honor.
It doesn't mean she wasn't.
Response, Captain.
That's not a
Judge,
requirement.
I don't think this is new information. This was never disputed. I don't think it changes the analysis.
On this particular point, the court has reviewed the transcripts of the depositions that were cited by the renewed motion, and the ruling will remain the same on this issue as before. These matters go to the weight of the evidence and not the admissibility. The jury, as the trier of fact, is going to decide what significance to give to the evidence. The defense also is free to cross-examine on all issues that pertain to Mrs. Adelson being free to travel. The matters that have been previously raised within the motion to suppress and ruled on as to the phone calls and other evidence, that also will be presented to the jury as well. They will make up their mind.
Thank you, sir.
He's just so damn reasonable, logical, and follows the law and lays out his reading or his reasoning. The court basically sounds like the rules of evidence at this point. Look, the fact that Donna Adelson was not restricted from travel, that's part of the defense argument. The defense is like, she wasn't under arrest. She was allowed to travel. That's conflating the issue. She is allowed to travel. She could go wherever she wanted. But there was a reason she was going to where she was going. It's not like she was headed to Boston. You know, she wasn't in Indianapolis because there's a Kura. She was on a one-way ticket to a country that she was on a phone call talking about whether or not they had extradition. So the fact that she was free to travel is not the issue. The fact that she thinks, because consciousness, this is her thought, do her actions indicate she thought that she was going to get popped and arrested after Charlie went down at trial? Did she think that it was coming for her? And did she think that if she was in Vietnam, it wouldn't come for her? She's talking about a plan A and a plan B. She's talking about who's going to be in charge of her affairs, who's going to take care of the money, where everything is. She's having conversations like she's not coming back one way or the other. So the court said, you can argue it, you can cross-examine on it. The jury can decide what it means. Does it mean she was going on a vacay to get a little tan? Get some good food? Or did she settle her affairs in the US so she never had to come back? The jury can decide on that one-way ticket. And that's what the court ruled. It's like 2 tickets to paradise.
Well, I believe that covers the defense motion.
Yes, they can play the phone calls in court. Those are admissible. We covered the rulings on the phone calls in court. The defense made some valiant attempts, and those rulings, the law was not on their side. So the court's like, we're at the end of the motions in limine. Thank you, Your Honor.
And Ms. Cattleman, you stated that the state did not have an additional motion in limine that not already been previously ruled on.
That's correct, Your Honor.
Judge, there's one additional one also filed on July 21st concerning the opinion testimony of Jason Newell and Patrick Sanford.
Oh, yes. Go ahead as that motion.
Sorry, Your Honor. I'll stand on the motion.
Ms. Cattleman, response.
Judge, the defense elicited personal opinions of these witnesses at deposition about the lawyers and their ethics and how they think they might have been involved in the new investigation, and now seeks to suppress those opinions, which are clearly inadmissible. I don't understand it. I don't know why we're doing it. I would never elicit such a thing.
Well, Ms. Cattleman.
I love the DA so much. Excuse me, Your Honor. What? We'll go over this motion regarding new investigation now that it's come up. Your Honor? Huh? We're not just wilding out here, Your Honor. There's rules. I just follow them.
Even though it might be inquired into at deposition, ultimately, if there's a basis to exclude it pre-trial, that's why it's being raised now.
Of course. There was no reason to elicit it at deposition, and then it could never be admissible at a trial. So we're just wasting paper and time, these motions. No objection.
The state is conceding the issue. The motion is granted as to any opinions that would be offered by either investigator Newland or special agent
The court sounds like
Sanford.
he's smiling.
Again, there must be a proper foundation for them to offer an opinion on a subject if they don't have the ability to do so. It cannot be presented as a part of the case in chief.
The prosecution's answer was, ew, David. Stop filing shit that's dumb. Don't dumb at me. We're not new here. Take your motion, get out. We're not going to do it. We're not just here to make motion after motion after motion. I have other shit to do. Stop it. I love the vibe so much. Ew. Also, I just need you all to know there is someone who lives in the Middle Tennessee area. I do not know where, because I see the car on occasion, but not always, that has a personalized plate. Their personalized license plate literally says, ew, David. And if this is you, just know that every time I see this car on the road, it brings me joy. It makes me giggle. It makes me happy every single time I see it. But yes, someone has an ew, David personalized license plate, and I freaking love it. All right, continuing on.
I don't really see a context in which this might come around, either in rebuttal or as far as impeachment. But again, these rulings are being made as to the state's, the substantive evidence the state may present as a part of its case in chief. If it needs to be readdressed as a matter of either impeachment or rebuttal, we'll take it up at the appropriate time. All right, let's go ahead and talk through some of the logistics for jury selection on 8/19. We are going to be in this courtroom once again. I believe.
Excuse me, Your Honor. Pardon me, I'm chewing. Well, we're talking logistics. Can we talk about the microphones, please? Can we talk about the microphones?
The number of jurors that we have under summons right now, or prospective jurors under summons, I believe it's near 300. So what we're going to do on that Tuesday Essentially, we will have the pre-screen of the jurors on the issue of pretrial publicity, similar to what we did in the last trial. The court will be asking these same questions, or substantially same questions. Both parties will have an opportunity to follow up on the court's questions on the issue of pretrial publicity. If a prospective juror is deemed suitable to return for a group voir dire, from there, they will be given the date and time for which group voir dire will begin. For the pre-screening that would take place on both Tuesday morning, Tuesday afternoon, potentially Wednesday morning and Wednesday afternoon, I would anticipate by that point we would have a suitable pool of jurors from which, going through the pre-screen process, anyone who has had an issue or either the court believes, the state believes, or the defense believes is not suitable to go to the group voir dire. From there, each party will have an opportunity to make their objections known as to that prospective juror, and either they'll be told to return or they will be excused at that point. Does anyone have a question about the pre-screening process?
Can we get better
No,
microphones?
There you are.
Also, as well, so that we don't have any issues
300
similar to
jurors.
what occurred in the previous trial, in which I believe there were allegations the jurors were speaking to each other. We are going to have additional bailiffs. The prospective jurors are going to be instructed not to speak to each other. It might make a long day for them, but they will be sitting in silence. We will provide reading material to them, and we'll have extra bailiffs on hand to
I have a question. What's the list of reading material? And can I make suggestions?
ensure that no one is speaking to each other while they're waiting to be screened. Does anyone have anything they need to raise concerning those?
Is it your honor's intention to handle the pre-screening, I don't know what it's called, instructions that happen down in jury assembly?
Yes. I believe the last time, I'm not sure if someone else qualified or not, but for each group that will be qualified, I will do it personally, so that way from beginning to end, they're seeing me, hearing me, and understanding you're not to discuss the case or anything else with each other.
300 are going to be
Perfect, that's
screened.
the state's request.
300.
Judge, how many of the 300 are coming each day?
Broken up into groups of 50. So 50 in the morning, 50 in the afternoon. We may not even need to get to the end of this grouping altogether.
Right. If they go through the first 100 and get a jury, then they're done. They don't need all 300.
We're able to go through the pre-screening process on the issue of pretrial publicity. Once we have, say, 100 to 110, that's more than enough to get 12 people.
How do you intend to handle proceeding once we successfully select a jury?
Once we have selected a jury at that point, and also I believe too, we'll need at least 2 alternates unless the parties wish to have 3.
Defense would request 3, Your Honor.
Very well. Then once we have our 12 jurors and 3 alternates, at that point, we will swear them. If we have enough time to actually move into opening on that same day after the selection, we'll do that so that way we can start to begin into witness testimony seamlessly without issue. How many days is the state anticipating to go through its case in chief?
I think best case scenario is 5, worst 7. So 6. I could see how it could run into the first part of the 7th day, Judge. I think 6 is a comfortable estimate.
All right, let me bring up my calendar.
5 to 7, so 6. This is the part I hated the most. Emily, how long will this take?
Assuming
long
that
it
we
takes?
have a jury that
Like, It depends on how long they talk for. I mean, shit can happen. Hated giving trial estimates. And I would generally ask people, this is what I'm doing. What do you think? Time blind.
Friday, the 22nd. Then roll that in place. August 25th through September 2nd as the state's case in chief. I think there is a holiday on September 1st, correct?
Yes.
Is anyone volunteering to work on Labor Day?
No.
Jackie is.
I need one other hand, unrelated to that side of the table.
Thanks.
It is a holiday for the workers of the world, but we cannot forget that we have a trial to finish. All right.
You're allowed to do that in Florida? Oh. No. How are you allowed to do? You're allowed to do that? Huh.
5 through 9-2, then we're estimating as the state's case in chief. How long is the defense estimating to present any case that it wishes to do so?
Can I weigh in on that before they speak, Judge? We have historically picked a jury in 3 days at the longest. Twice we did it in 2 days. So my suggestion would be to start on Friday. We could even do openings as early as Thursday, if Your Honor was willing to entertain that. I know that's not the defense's request, but that would be the state's request, just to move it on as quickly as possible.
Well, for the openings only, does the defense have a position concerning this?
Judge, we don't want to make the openings unless we have a great deal of time after we pick the jury on a particular day. We would prefer to do the openings the next day.
So you're not asking to defer your opening to your case, you just don't want to open on the same day?
It's going to depend, Judge, on your ruling on the additional motion.
Oh, right.
Just for a moment to explain. The court asked the defense if they were going to defer their opening. We haven't watched a trial where the defense has deferred their opening. It doesn't happen all the time, but it can happen that the prosecution gives their opening statement, the prosecution gives their case in chief, and then before the defense starts their case, they give their opening. So the defense can defer their opening and not go after the prosecution, but go at the break. Emily said technically Brooks did. We didn't watch the prosecution's case. So yes, but we jumped into that case in the defense case. So fair. But you can split it. Most defense attorneys choose not to split their opening because they want the jury to hear from them before they see everything else. So I had totally forgotten about Brooks. So thank you. Brooks, again, representing himself. That surprises me not. So let's continue on. But yes, you can split your opening.
On that matter, again, depending on where you're at time-wise, I'll just instruct both parties to be prepared to potentially give their openings. I'm not going to place a time limit on the opening statements, but obviously, well, each party will be the captain of its own ship as to how you will captivate the jurors. Is either party expecting their opening to go beyond 30 minutes?
The rider of their own horse, the captain of their own ship. I will leave it to each party as to how they will captivate the jurors.
Depends on your ruling, Judge.
Ms. Calvin.
Yes, I think it could be up to 45 minutes. It's not going to be different than it was previously, but I'm sorry, I don't know how long it was. I would say 30 to 45 is comfortable range, Judge.
The thing is, a lot of you are saying, wait, the lawyers just get to decide their own time limit and be responsible? Yes. Because here's the thing this judge knows. A, this judge has done a lot of this trial with this prosecutor, as to the other defendants, but also, if you bore the ever-loving shit out of a jury in opening, you have done yourself a grave disservice. It is best to keep it a concise overview. So when the court is like, it's up to you how you will captivate the jury, they know. However, I imagine that in different cases that we've seen, there was concern that certain attorneys would go on forever if not given a limit. So it really just depends on the attorneys and the court, and if the court trusts the attorneys to not just never stop. Let us continue.
Right. As to the defense case, once we are finished with the state's case, how much time are you estimating?
It depends on your ruling, Judge, but anywhere between 4 and 6 days.
4 and 6 days. So that would place us then around the week of September 8th. All right. Concerning any other matters that we can address as the logistics of the trial, I believe we will have rooms available for our family members, both for the victim's family and for the defendant. Do the parties anticipate making use of these rooms?
Yes, Your Honor.
Yes, sir.
All right. Please contact court administration. From there, you'll receive information as to how to access the rooms and when they will be made available.
Judge, can I clarify your intentions about when to start testimony?
Go ahead.
You intend to start testimony on the 25th, is that right? With the possibility of openings having already been conducted?
Well, at the latest, if we go into Friday with needing to select a jury,
Okay. If we get a jury,
if we get a jury prior to that Friday on, say, the 21st,
Oh my God.
really at that point, there's nothing preventing the testimony from getting started on the 22nd.
okay, so I'll be prepared to start testimony on the 22nd then. And my understanding was, and my subpoenas run through September 5th, but it sounds like we might be extending into the week of September 8th. Is that right?
Well, I believe the defense is indicating they might need anywhere from 4 to 6 days.
That's what they said. All right, so we could potentially go
I wish I was in charge of this audio. I really do. I am not.
through the week of the 8th.
If need be.
All right, I will attempt to get subpoenas out for rebuttal for that week, but I will advise the court that as of right now, those are not out.
We are losing a day because of September 1. But if need be, we can figure out logistically how to make this work for Saturday to continue working. I'm sure you all would like a break, but I'm here.
The court's like, let me know if you need me.
Matters of logistics they need to raise concerning the trial.
Yeah, Judge, we're going to have an issue regarding space. We're not all going to fit here. We also don't want our computer screens facing cameras and the audience being able to see what's on our computer screens. I have become very old, and the font size I use is very large, and probably someone in the back row can see what I have on my computer.
I mean, ma'am, for real, same with me, but people are allowed to sit behind you. I completely agree that the cameras should not focus on their screens, but you can get a privacy screen. You can get a privacy screen. But also, like, I get it. I'm trying to move the closed captioning.
See what's on our computer screens. I have become very old, and the font size I use is very large, and probably someone in the back row can see what I have on my computer. So we're going to need to have, I understand we're blocked by this column,
Right.
but we're going to need to have some kind of setup where we can put our things and our defense not be disclosed ahead of time to the media and blogs and this and that. The second thing is
Everybody's so worried about the
these
logs.
microphones used to have the ability that you could touch it and it would turn off. My client is hard of hearing, so she talks loud. So everything she says is going to be picked up. This one is now set up so you have to press it each time you want to mute it. And
Press and hold.
right, press and hold. You got to hold it down for it to continue to stay muted. And
I don't even think that microphone's on, ma'am. I got to be honest. I don't think that microphone's on. I really don't. It's a real concern. I am not downplaying her concern about the microphones picking up her conversations with her attorney. I really liked how they mic'd the podium in the Paltrow case in Utah. But then when attorneys made the objections, they had to go to the podium. I really appreciated it. It made it a little bit easier. Get a notepad, though. If your client's hard of hearing, don't try to talk to her during trial because the jurors will hear her. It is not a huge courtroom. Get a notepad and a pencil or whatever. But I liked the way that it set up the microphone in Paltrow. I understand the defense's concern. It is a real concern. You don't want people overhearing hot mic of your case because the prosecution can go back and see it later because it's being streamed. Like, I get it. Continuing on.
And we're going to ask if the court admin could put it back to the function where we can push it off. I don't think there's going to be any opportunity in the trial for someone to not pick up on a recording Mr. Zellman's voice. He's very loud. I tend to be loud too. So it's not going to be a record issue in our position, but it's certainly going to be a problem when we're trying to speak to our client about something because it's going to be heard.
Well, in front of the jury, I definitely understand the concern that you're registering with this. What requires that can be done for the microphone on the table. If your client does need to write things down, so that way nothing is being given away, that might be the easiest way for that to be handled, but
Yep.
that requires the microphone. The seating set up in the gallery, I believe the first two rows behind the defense, those are not going to be relevant to any members of the media. As far as the font size on your computer, if you need to rearrange how you're seated at the table, so if you need to seat on the far left, or my right, your left, so that way your computer can face the wall and no one can see it.
Ori, the hearing aids don't seem to be the thing for Donna. There's an ear canal issue. They talked about it at another hearing. Also, in custody, there are some difficulties getting hearing aids, which is a real problem. But some of this is ear canal issues. Also, we have heard Donna speak in hearings. She does not speak loudly as if she cannot hear herself. She was speaking in trial or in the hearing that we saw in a fairly regular tone. She was not shouting. In fact, Donna was not speaking even nearly as loud as my father in his 80s who has hearing aids. The hearing aids, again, don't necessarily fix everything, but the defense is saying, well, Donna speaks loud. In everything we've heard from Donna speaking, she does not speak all that loudly. I think the concern is overblown. I don't think it is I don't think it is a huge issue, but because I don't think Donna speaks all that loudly. However, it might just be that when Donna was speaking in court, she was speaking to the judge. Maybe Donna thinks her lawyer can't hear her. And so she's yelling at her lawyer, not because she can't hear, but because she thinks her lawyer can't hear. I don't know. She did not strike me as someone who was speaking at a volume that was inconsistent with the requirements of what was happening. So overblown concern is where I'm at. But it is a concern that people will try to just listen in on everything the defense says or peek over their shoulders. And stuff had happened in the last trial that there was some concern about. Let's continue on.
I don't really know what I can accommodate you with as far as that font says beyond that.
The problem is the end of the table it's not open. It's the leg of the table. So I don't know if we can add a little something, another table that is the same size.
What I've tried a 3 co-defendant first degree murder trial in this room before, and what we had done.
That doesn't even seem like enough room. There definitely doesn't seem like enough room for that. So Linda, I agree with you. Linda said audiologists hear when people are hard of hearing, sometimes they talk louder because they can't hear themselves. It's pretty common. I don't disagree with you. I disagree that is the situation we have seen in court. I don't think that's what we've seen in court. So her attorney saying Donna speaks loudly. Her attorney also said Donna's breathing was so loud that it disrupted everyone, and Donna came into court and was speaking at a normal to low volume, and you couldn't hear her breathing even though a microphone was up in her face. The defense is perhaps embiggening the issue, but the microphones should be able to be muted. However, it's weird where that pillar is in court. I don't know if you can see my pointer. That pillar might block the view of the judge. It's just an odd space. And Crazy Cat Queen, the attorney might not have heard of a privacy screen, honestly. Truly.
Was one table was between the column and the bailiff's box. There was a table here and then this table here. I think that if we could put a table to our left, that might be one way of accommodating this need.
Right. Please make a request in the court, and then we will figure out the best way to try to configure the tables. Ultimately, for what needs to come in with, I believe the state is going to try to, needs to bring in its equipment, audio equipment.
Yes, Your Honor.
All right. Because of that equipment and how that will need to be set up, the tables and how they're configured can't interfere with that. We'll try to accommodate that as best as possible.
The jury's on the other side.
It's compliment as to the audio or visual needs of the state other than what has been used before.
The Emily has audio visual needs. Excuse me. Emily is no longer the state, but the Emily has audio visual needs, and they are on behalf of all the law nerds and all of our neurospicy difficulty. WTF with this audio, because it's breaking all of our brains, and we can't speed up the pace of the conversation because the mics are so bad, but also we're struggling, Your Honor. We're struggling
with the audio setup. Is there anything that needs to be addressed?
That's not what he's talking
No,
about. He's
sir,
talking
it'll
about
be the
court
same setup with
presentations.
the same company.
All right. Probably then they'll need to get started by the 15th in this room so they can set up all equipment, test the equipment, and if there's any problems, we'll be able to figure out what needs to take place before we actually get started on the 19th.
He's giving them time to set up the courtroom to make sure it's ready for trial. That's so lovely. That's so lovely. That's so lovely. That's just, I love all of that. My you have 30 minutes, if it doesn't work, move on, PTSD is kicking in. But it's really nice that the courthouse can accommodate that and make sure everything's running smoothly, and has given them time. Hey, come in by the 15th, which is what, Friday? Come in by the 15th and make sure everything's working. You have time in the courtroom to get it set up. It's also amazing that the judge isn't like, I'm sorry, I have 75 cases on calendar every day for the next 4 days, so figure it out. He's like, let's make this all run smoothly together. I'm so here for it.
All right. For the media presence that will be here as well, I believe it will be similar rules as it's been in the past. There will be one live video camera. There will be one still frame camera. Obviously, the bloggers and reporters, they are permitted to take notes as if they were print journalists. But the initial rows behind the state, Ms. Kapperman, I assume the victim's family is wishing to appear.
Yes, Your Honor.
All right. They will receive priority seating with regard to how they're positioned in the gallery. After that, it will be free to the public and the press to seat in all areas that are available. Does either party need to be heard concerning those?
Your Honor, we're also in need space for our client's family and
Behind
friends who are
you.
going to be coming to support her as well.
Then behind
And we
you.
request that they have similar priority seating as the victim's family.
He said that. The two rows behind you.
Two rows will be
He said that
behind
already.
the defense. That will be available to family and friends.
Yeah.
Again, similar to last trial, other than the video recording and still frame photography recording. Beyond that, no cell phones are to be out recording any other matters or trying to take photos of the witnesses or the jurors. I believe similar in the
It's so dumb to me that people in the audience would even try to take photos or video from inside court when court's being streamed. It's just like, what? They've allowed access. Just adhere to the access that's been allowed. This isn't a court that's not transparent. So I'm going to find out who Poole is. I'm optimistic.
last trial when Special Agent Jimenez
It will be better.
testified. His face was not shown, obviously, because of the nature of his past work. The court will just make the same ruling concerning that as well. His face is not to be shown, but of course, the substance of his testimony certainly may be reported on by anyone who believes it is newsworthy. During the selection of
That's
the
very
jury,
rational.
the faces of the prospective jurors are not to be shown. Their names are not to be shared. But as far as any biographical type data, such as the composition of the jury, being, for example, 7 male, 5 female, what their professions are, those are certainly able to be reported on by the members of the media and disseminated. But ultimately, what I'm getting at is names and faces, so we don't have any disruption or disturbance during the trial.
Right, that's very
Do any of the
rational.
parties have any questions concerning those?
No, Your Honor.
There you are. One last thing, typically, I don't think I've had a trial with you quite some time. Typically, my paralegal sits with us, so that's another reason why we need that additional table. She also may
There will be somebody pulling things up on the computer. Fair.
have some additional people assisting her. And I'll make sure that they're identified to the bailiffs so
There
that
will be a team.
there are no issues there.
The members of the direct support staffs may sit on the benches that are behind the attorneys, or if we need to figure out a table configuration for them, if we have the space. But the direct support staff is permitted as to both sides. Does either party have anything further to raise concerning the logistics of the trial or any other issues before we finish?
No, Your Honor.
There you are.
One other matter comes to mind if the attorneys can briefly approach.
Okay. The attorneys are approaching. Oh, the super zoom. Can we stop with this? Thank you. Just no super zoom. Look at how big I love seeing the binders though. A massive binder, but it's been a number of trials. A lot of people have testified. Thank you, Miguelina, for cutting down the time when they approached.
Just will be in recess.
The defense was speaking to their client. The court is saying that they are going to go to recess.
For today, the jury selection will start August 19th. at 8:30 in the morning after the initial group of jurors has been qualified. From there, we will move into the pre-screening process as previously discussed. Have a good day, everyone.
Thank you, Judge.
So there we are. The trial of Donna Adelson is going to begin August 19th. We won't be seeing it on August 19th because they're going to pre-screen the jurors. We are going to be waiting for opening statements. So Donna Adelson will begin jury selection in her trial, lest something extraordinary happening, on August 19th. That's next week on Tuesday. The court has indicated, Emily, you need your calendar? Yes, I need to see it. So next week, Tuesday, and then we'll run through the week. So possibly Friday as well. The court said once a jury is seated, they are going to move right into opening statements. They expect the prosecution's case in chief to start by August 25th at the latest, which means we might be in trial sooner. Now is the time for me to remind you, if you need trial snacks, A, we have a sponsor today with Wildgrain. You have time to get your order in. B, if you are ready to be on trial watch, get the Lawnerd app so I can keep you in the loop, because Tuesday they're going to start jury selection. We will cover other topics, but then we're going to be waiting to see if a jury is picked quickly. We're going to roll right into opening statements without a lot of heads up, truly. So I will let you know. We're not going to be able to plan what day we are doing opening statements. The court's like, if a jury's picked, you guys have a half an hour, we're doing opening statements. So this trial, like others, you are going to want to make sure you have the Lawnerd app. And I'm going to make sure that my travel plans work accordingly. So we will, well, I will do my best. We will see. Either way, we will catch up with anything we need to catch up with if anything is missed. But trials are dynamic and we have no idea how it's going to go. So what we saw today was mostly in line with this court being consistent. The motions in limine were all addressed and ruled on. And for the most part, the court said, if it's evidence, it will come in. If it might become relevant down the road, we will address it then. If it's clearly not relevant, not admissible, it's not coming in. And to those motions, the prosecution has said, obviously, we wouldn't try to do that. This prosecutor has prosecuted this case or these cases multiple times because the prosecutor has been on Charlie Adelson's prosecution wherein he was convicted. Catherine Magbawana, I think is the proper pronunciation of her last name, which was a trial, then a retrial. She was on the trial for one of the hitmen, and then one of the hitmen pled. So 2 trials for Magbawana, 1 for Charlie, and 1 for one of the hitmen. The other hitman pled because he had other federal cases. So 4 times. They've done this case 4 times, and now is Donna's turn. The question that looms large for everybody is when is Wendy's turn and what did Wendy know? But we're going to get to see that fresh because for those of you that have watched the Charlie Adelson trial, I did not watch the Charlie Adelson trial. Thank you for no spoilers. I am interested to see if Charlie testifies this time. I'm interested to see how Wendy testifies. And perhaps if we have time, we will go back as a group of Lawnerds if we want and go back and watch Charlie Adelson's trial after Donna's trial is done. And then we can juxtapose the two if we would like. So I know it's hard with no spoilers when there have been trials that have gone before that we have not watched, but there have been trials that have gone before that I have not watched. So we're going to see what happens, but this is the next trial that we are watching. I really hope, I really hope that, that this trial goes smoothly, that it starts when it's supposed to, that Donna testifies, those are my hopes. Crazy Cat Queen had a great question and I tried to go grab it and then I couldn't find it. So I wanted to just answer it. Is the public normally allowed to observe jury selection? In person, they are, but they are not streamed. Sometimes they will stream it without showing the jurors and just hearing the audio. I don't think this court has done that. So we will see. The Lauren asked, what about Wendy Adelson's dad, Donna Adelson's husband? Has he been arrested? No. And as we go through this trial, I'm sure I will have more thoughts on why. So we will see. Ori said, yes, I heard Charlie's trial was wild, but I didn't watch because no law nerds in EDB. The time did not work out with other things that we were doing. And then when Donna got arrested, I was like, the mom? I'm in. Okay, tell me more. Tell me more about the mom. Tell me more about the mom. So then I was in. We should get to Q&A. I was going to pull up one motion. I'll swoop and pull it up real quick. I had forgotten. Thank you, law nerds. I wanted to pull up the motions about the new investigation as to Donna, and we've got a minute. And then we will get to questions. For those of you asking about the hearing tomorrow, it is my hope that we are able to cover the hearing tomorrow. I don't have an answer yet on how that will be broadcast, if that will be broadcast, or what the fuck is happening, but that's an afternoon hearing. So when I know something today, I'll let you guys know in the app, and we'll do our best. So, new investigation into Donna Adelson. Let's talk. That swoop was too short for me to pull up my documents, but we're doing it anyway. All right. I've got them grabbed in my prep document. I think hopefully both of them. I've been trying to keep up with all the litigation in the Lively Baldonia cases, and I have been run over by paper. So I have been trying. Peggy, the hearing tomorrow is an ongoing discovery hearing with regard to all of the federal discovery in the Proctor fallout. That's the hearing we watched yesterday. And then the part of the hearing, my stomach is rumbling. And then the part of the hearing that I really wanted to see was not anywhere and still isn't. And maybe it will be up by tomorrow and we can cover it tomorrow before the other hearing, but it is ongoing discovery because there is a pickle with regard to Proctor and the feds. So the 5 cases are Johnson and King and Walsh. There's others, but those cases are all dealing with Proctor problems. And I'm very curious about how that's all going to go. So, Donna Adelson's new investigation. Shall we? Oh, yes. Oh, yes, we shall. Yes, we shall. Let us take a look at this document together. Let's see. This move over. All right. This was filed on July 29th, 2025. Defendant's motion in limine, new investigation redacted copy. Slushy Slush Fun asked if I ate my croissant. We're not all the way done yet. I was taking notes. And we were taking notes. Defendant Donna Adelson, by and through her undersigned counsel, pursuant to sections of the Florida statute, request, and they list them. I didn't request this honorable court exclude or limit introduction of evidence from the new investigation, and in support thereof states as follows. Emily, why are we covering this? Because tea. This isn't going to come in this trial, but I want to know. Don't you want to know? I want to know. So that's why. Because the prosecution's like, Your Honor, it's not relevant. So no. On April 7th, 2025, the state disclosed the existence of a new investigation that began after a jailhouse informant contacted the state in December of 2024. The first informant's information led to a second informant. Both informants made statements which were consistent on a limited basis. The vast majority of the first informant's claims were either established to be false or could not be corroborated. By this motion, Ms. Adelson moves to exclude evidence from the, quote, new investigation. During her interviews, redacted, and then it says should be inadmissible. Alternatively, should the court find any of the allegations be admissible under section, Adelson requests the court limit admissions of evidence to that which satisfies the balancing test right in the rules of evidence. Statement of facts. Individual was interviewed December 20th, 2024, January 13th, 2025, January 29th, 2025, and February 11th, 2025. For example, redacted. The new investigation failed to produce any evidence to corroborate these claims. Redacted. The new investigation failed to uncover any evidence to corroborate this claim. Redacted. The new investigation failed to uncover any evidence to corroborate this claim. Redacted, 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 redacted. Redacted. Continued redactions. So these are all claims made by a by an informant in custody against Donna. On April 2nd, 2025, additional informant or individual was interviewed by law enforcement. During this interview, they made numerous claims about Donna Adelson. The undersigned deposed on July 17th, 2025. Redacted. The new investigation failed to uncover any evidence to corroborate this claim. I'm making this a giant asterisk because I want to read this after the trial. This is redacted so that it doesn't taint the jury pool because it's not admissible evidence. But after trial, it shouldn't be as redacted. Bird confirmed telling the investigator that I cannot pronounce, my brain cannot put the letters in the right order for Magbanwa. My brain is just backwards. Notice the information about the go-between is not redacted because that is the go-between. All right. Bird confirmed telling the investigator that Magbanwa was arrogant and manipulative and got special benefits from guards. She also said that Magbanwa told the whole pod that her boyfriend paid for her boob job. And so goes on to say, the original investigation failed to produce any evidence to corroborate that blank, but suggested that Magbanwa, I'll get it eventually, paid for the boob job at least in part from the money she received on July 18th, 2014 from Donna Adelson. It suggests that the go-between, and I could see why the defense would want to bring this up, right? It suggests that the go-between didn't pay the hitmen. She got boobs. And so, look, boobs are great. Fine, get boobs. Why does the defense want to know about the boobs? Well, if the prosecution is alleging, which they are, that the money that was paid to the go-between was supposed to go to the hitmen for the murder, her using the money to get boobs might discredit or undermine the allegation that Donna Adelson was paying for a hip job. But also, why would Donna Adelson pay for somebody's boobs? Also, wasn't she dating Charlie Adelson? So, like, also couldn't both things be true? Sheila in the chat said, are they going to repo the boobs? No, because I mean, her money, but I had a case like that. So okay. She is suggesting the in custody informant is suggesting that the go-between didn't pay for a hit, she paid for boobs. So, Morgan, it was an implant case. There was fraud involved. Repossession was a conversation. There's a whole story. Redacted, significantly redacted. But also, I want to see this argument play out in court. Isn't it true that you didn't pay dude to murder Dan Markell? Didn't you just pay for boobs? Or both? Because she's in custody for the conspiracy to commit murder. Discussion. Evidence is not as admissible as Williams' rule of evidence. And then they're giving the rule of evidence. The prosecution conceded and said, why are we doing this? I'm like, what? Collateral crime evidence is admissible if it's relevant and has highly probative value in proving some material fact at issue in the instant case, which is not going to happen here because whatever they're alleging Donna did, which I have seen many headlines that suggest that they're alleging that Donna was offering to pay people to testify for her. It doesn't matter if they can't corroborate it unless it comes up as consciousness of guilt, and the prosecution's not trying to bring it up. So the prosecution's not arguing that it's admissible evidence. So we're not going through the defense's reasons why it's not admissible. I just think it's hilarious that the entire damn thing is redacted. And I very, 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 very much want to put an asterisk on this so y'all can remind me to go back when it gets unsealed and cover it because now I want to know. I want to know for sure. Evidence is not admissible as consciousness of guilt. Right. Because that would be the argument. If someone is asking someone in custody to testify to something that they might not know, that might not be firsthand, that might not be true, it's consciousness of guilt. The argument is, oh, you're asking me to lie for you because you know you fucked up. Nobody asks you to lie for them. At trial for murder, if they don't think that they fucked up. Like, consciousness of guilt is the, oh, this action proves you think you fucked up. So, Megan, I don't know if the boob job came up in Charlie's trial. I imagine if he paid for the boob job, it probably did come up. So, evidence is not admissible as consciousness of guilt. For this discussion, there are two separate issues to analyze. Redacted, killed, period. That's literally what it says on the page. Additionally, the undersigned acknowledges redacted. Thus, even if informant's claims are truthful, redacted, absent evidence redacted, based on this discussion, redacted, brings us to the second issue, redacted. The undersigned concedes that generally speaking, such evidence is admissible. However, the evidence must be truthful and its probative value must not outweigh the danger of unfair prejudice. It is the defense position that the claims made by the two informants are false it is axiomatic that no party is permitted to present false or perjured evidence. Aside from innocent details, there is no evidence that corroborates the substantive claims. Additionally, Adelson objects to informant testifying absent an opportunity to depose her. The state waited to disclose this new investigation until 5 weeks after they last had contact with Bernhardt and 3 weeks after a warrant was issued for Bernhardt's arrest for violating probation, as well as an order to show cause pending in that case. So there's another case going on with the informant. I wonder if the informant was trying to, this is pure speculation on my part. I just wonder if the informant was trying to negotiate some information, knowing that there were other things pending while she was out of custody. Evidence is not inextricably intertwined. The concept of inextricably intertwined evidence removes evidence from consideration under the admissibility under the Williams rule. The Honorable Milton Hirsch stated that at common law, inextricably intertwined evidence is defined as other crimes evidence which must be indivisible from the evidence of the charged crimes, such that the tale of the charged offense could not be told without relating the evidence of the uncharged offenses. Hirsch, quote, "This newborn babe and infant Hercules, the doctrine of inextricably intertwined evidence in Florida's drug wars from 2000, is the title of the article." What? What? I need to know how that title is about the doctrine of evidence in Florida's drug wars. What is this? What is the title? And for everyone chanting Hercules in the chat, yes. But what is this title? The newborn babe and infant Hercules, the doctrine of inextricably intertwined evidence in Florida's drug wars. What is this? I need to read this law review article. That's going to be a side quest. It might be after trial, but that title, look, it worked. My interest is piqued. I am curious what the newborn babe and infant Hercules has to do with evidence on Florida's drug wars. I'm just real curious. I'm just real curious. However, the defense is citing quite a substantial amount of law in this. The prosecution already conceded it. So I don't think we need to go through the ballad of the unborn babe Hercules at this point and all of the case law. The defense is saying the vast majority of claims do not survive the 403 analysis. The defense concedes that, redacted. The remainder of the testimony is likely admissible. The same is not true concerning the varied claims made by the other informant during her multiple interviews with law enforcement. She is located for, if she is located for trial, and only for those claims which are relevant, the probative value of almost all her claims is substantially outweighed by their prejudicial effect. It seems to me that the prosecution does not want to get into this circus sideshow of whatever they are accusing Donna of doing in custody. And so they're not even interested. I mean, could it come up on rebuttal? Maybe, but it seems that the prosecution is pretty confident in what their case is going to look like based on all of the cases they've done before. The only statements from that informant which arguably survive the balancing test are redacted. Wherefore, the defendant, Donna Adelson, respectfully requests that this honorable court mention or grant this motion in limine, enter an order prohibiting the state from introducing evidence from the new investigation, or alternatively, limit the admission of new investigation as set forth. And the prosecution was like, I'm not doing this. I'm not doing this. I just wonder if the allegations in custody, and I've seen quite a lot of articles indicate that this is believed to be Donna attempting to perhaps sway some testimony or purchase some testimony or get a little phone a friend in trial. So let me make sure there weren't any other motions that we needed to look at regarding the new investigation, because I was more curious about that than the rest of it, because we've seen the court rule on the rest of it, and there was nothing incredibly novel. Lona in the chat said people don't want her wet money. Right. It smells weird. Let's see. This is the same motion. I don't think I have anything else on that new investigation that's coming to mind. So I'm very curious what's going to come of that. The prosecution said it's not going to come up. We'll see if Donna opens that door in her own testimony, because that can happen. Give me one sec. Emily, should we have done this when we prep for stream? Yeah. But I'm curious. So I'm looking to see if there is anything else on that. And I'm not seeing anything that's really substantive, but I'm not surprised that the prosecution is like, fine. And the new investigation has all been turned over. So we'll see what's going on with that. But let's see. This is coming from WCTV in Florida. And again, this is not going to come up in this trial. There have been some motions on this. They've all been denied. But out of completeness and curiosity, new investigation leads Donna Adelson's defense team to seek trial delay. At a Wednesday hearing, and this is from April 30th, so we were well and truly in the Karen Reed case while this was going on. So if you're like, wait, what? We were busy. We were busy. Covering the trials. At a Wednesday hearing, prosecutors said they continue to investigate Donna Adelson after receiving a lead last fall. The defense team says they need more time to prepare. Donna Adelson's trial on murder, conspiracy, and solicitation is set to begin June 3rd. It was delayed. That's why we're here in August. The judge said he would make a decision soon about delaying the trial. It was delayed till August. It was supposed to start in May. I was glad it was delayed because it would have been going on at the same time as the Reed trial. Do you think Donna just wanted her trial to be clear of any other high-profile case because she thinks her case is high-profile and wants the attention? Anyone? Maybe. We did glean this. Law enforcement restarted its investigation into Donna Adelson after they received a, quote, lead last fall. However, the investigation won't lead to new charges. Even though the charges will remain the same, Adelson's defense counsel said they need time to review all this new evidence. They said they spent the last 3 weeks reviewing evidence and listening to wiretaps instead of preparing for trial. So there's even more conversations. The judge allowed both sides to take longer to file written motions, but didn't decide one way or the other. Defense attorneys have filed multiple motions this past month, including the motion for a continuance and the motion to have the judge disqualified. I covered that one and laughed. And then the judge said, nope. An April 10th filing labeled as exhibits in support of motion to change venue, but the motion itself is still shielded from view. We'll see that when things get unsealed. 16 different documents in Donna Adelson's case have been sealed from public view since the start of April, which is more documents that have been sealed in the rest of the case because it's that new investigation. So when this case is done and things get unsealed, this is what I'm most curious about. I'm most curious about what she's talking to people about in custody. And because it's not going to come up in trial, it's exactly the type of thing that should be sealed. The jury's not going to hear about it in trial, and it could taint their opinion of Donna Adelson if it came to public light. So, Donna, what you doing in custody, girl? I'm so curious. Who you talking to? Because they're trying to leverage whatever you said to them for benefits for themselves. They're going to throw you right under the bus of your own creation because they don't give a shit. And they would rather benefit themselves. Obviously. So it's going to be real interesting to see if this comes up at trial in any way, if the door is open to it in any way, and if Donna is trying to use money to get her way. Would that shock me? No, not in the least. I wouldn't be surprised. Does Donna strike me as can't we just pay someone? Yeah. So I'm not shocked. Let's get to Q&A. I'm very curious to see what Donna was doing. Donna, what were you doing in custody? And I really want to know if it's going to come up when she testifies, because you know she's going to testify. I imagine a lot of what you're going to see in the first part of trial is what was seen in Charlie's trial and others. Maybe it is, maybe it's not. But the defense case should be different. And will the state call Charlie? Will Donna's attorneys call Wendy back or just cross-examine her? I have so many questions. But there are definitely witnesses I'm very interested to see. All right, let's get to questions. Maribeth in the chat said, the whole crime is so convoluted. I think the crime for me is pretty straightforward. It's how they connected everyone back to it that can get a little like, how do we connect everybody to who? But the crime itself is like, hey, oh, this guy's getting spicy. The allegations are, hey, we don't want to murder, but we want that to happen. Like, we need someone to stop living. So can we find someone to just do that? And that's essentially what the case is charged. Conspiracy to commit murder, and solicitation of murder. So how do we make that happen is kind of the whole case. Now, the who talked to who and when and how they figured out who did it and the bump operation, how they know that this was hired out, all that can get convoluted. But the heart of it is seemingly we want this divorce case and custody case to go our way. And the easiest way for that to be accomplished is for the father to stop fighting. And if he stops fighting, then we will get our way. And I think the argument from the prosecution is going to be the only way they could ensure he would stop fighting for his children is if he was no longer alive, which is not rational decision making. So let's get to questions. Laura M said the laundered tumbler keeps drinks cold forever. Also, kiddo starts school Tuesday for the first time. I'm not okay. Laura, yes. You will have a harder time than your kiddo will. They will have a great time. You will have a harder time. It is all delightful. And then you'll get to the part when you're like, is it school now? Go see your friends, please. But yes, it is. Feel all the feelings. They will be fine. You will feel all the feelings. It will be okay. Lombebe said, recovering from spinal fusion surgery, needed this. Take care of yourself. It is a long recovery. Just, it was frustrating. Recovering from spinal fusion was frustrating. It was really frustrating. It is just a long recovery. And you're like, this is taking forever. Yes, you need that time. And once you've recovered and you've given yourself the time to recover, there is still a process to get back. But for me, the issues I was having that the spinal fusion fixed, the recovery time was worth it. But even when you recover from surgery, the recovery is not done. It took me a couple years for my muscles to stop cramping weird and things like that. But it is a journey. It is worth it. For me, it was worth it. So take the time to recover, because you don't want to make that recovery longer than it needs to be, which means you have to go slower than you want to, which is tough, real tough. So take it very slow. Also, if you can use cups to like rinse and brush your teeth and stuff, it'll make things easier. There was no forward flexion for quite a while. Wags said, this should say 40, but I have commitment issues. Finally committed to EDB and haven't looked back. Wags, I totally get it. Also, glad you're here. Look, the thing about memberships that's helpful, you get all the ridiculous members only content and behind the scenes of all of the stuff that we do, but it also tracks your time, which I can't do on my own. I need things to track things for me. And that is very helpful. It's like, this is tracking that for me, which I love. Isaiah Good said, woot, good to see you. Let's see. Welcome to our new members. Thank you to everyone who gifted memberships. Jess, I hear you. I see you. I think you sent the same thing in super chat. Thank you. And yes, anxiety is high. And I'm not going to downplay your anxiety. That is 100% not my intention. When I have anxiety about stuff that I do not have control of, I tend to focus really, really intentionally on what I can control. It helps me feel like I'm doing something, because when you feel like there is nothing you can do, that helplessness makes, for me, my anxiety worse. So I focus me on just the things I can do. And so whether that is cleaning, whether that is laundry, whether that is, whatever it is that you can just give yourself a little bit of doing so you feel like you're doing something. Somehow it, for me, helps my nervous system just relax. It's like I am controlling what I can control. I have done something. I have cleaned something. This at least feels organized. And then my body is like, okay, I've done something. I have done something I can control. I have moved something. And somehow my brain is like, okay, we have taken control of this thing. So everything else spinning out of control that we can't do anything about is over there. And I can control this. And that is how, especially when I feel like everything is too big, I focus on the small. So hopefully that helps. I control what I can control. And it is hard to let go of that you can't control that impacts you. It's real frustrating when shit impacts you that you have no control over. It's hard. And it's hard to take a breath and let it go. It really, really is. And I'm not suggesting that you let it go or that your worry and anxiety is not warranted. But I am suggesting that you can control what you can control, and hopefully it will help you feel like you can process everything just a bit more. So I hope that helps. Just, your anxiety is valid, but also take care of yourself. So hopefully that helps. And there's tons of old content. If you just need me yammering at you day in and day out, I am here to yammer. We've got this. We can do this. Look, this community is amazing. But I am also there. When I get anxious, I don't sleep. And when I don't sleep, then everything else goes fucking sideways. And then I just make everything worse. So I always have to find ways to like rein myself back in, because I get it. Chris, good to see you. Looking forward to your very helpful clarification of everything happening. Drinking my ginger tea and winding down for the evening. It has been summer and I have not done tea. I need to. Because I need to. Because my sleep schedule has been so screwed. So screwed. My Pokemon is yelling at me in Pokemon Sleep. My sleep schedule is a freaking disaster. That is my goal for the next few weeks when I am not like bouncing all over the place to get my sleep schedule just under control. I can control it. I can take care of my sleep schedule. That's about all I got. I can also try not to buy things that I think will fix my life that I will never use, because that is the other thing. I'm like, you know what? The world is out of control. You know what I need to do? Reorganize my closet. No, I don't. It's organized. Leave it alone. Maybe coffee mugs this time. Pick something else. I'll probably plant something, but also getting outside helps. It's interesting with Travis getting back from DCI and chatting about something like DCI. It doesn't really matter what it is, but when he is looking at going back to school, because he is now back to school, and the environment he'll be in at school versus vis-a-vis the environment that he's in core. The environment in core means that he does not really have to executive function much at all. He gets to just perform and sleep and occasionally pack his shit and very, very rarely do laundry. But everything else is handled. When to wake up, handled. What to do when you wake up, handled. What to eat, handled. When to eat, handled. Where you're going, handled. When to get ready for your comp, handled. What you're doing on the field, handled. When to stretch, handled. When to warm down, handled. All of it is, everything in your day is handled. Just handled, 10 out of 10. And then you get home and you're like, when am I waking up? So he and I've started helping him do his run of show for the day so that he has to get back to the executive functioning load that was gone. And so when he was traveling, he's like, I loved this. I got to show up and do the thing I love doing the most. I was outside all day. I was spinning, I was throwing, I was running. Everything was taken care of. No decisions other than, am I adding a peanut butter sandwich to the meal that I am currently eating? Those are the decisions that need to be made. Am I going to add Suica on my cell phone? Because yes, you can play Suica on your cell phone. I currently have the highest score in the family. Griffin is coming for me though. And so is Dr. B. So we now have a family Suica competition because they added it to Apple Arcade. It's a whole thing. So when Travis was coming home, he's like, I didn't really notice my ADHD at all when I was on tour. I'm like, well, ADHD largely for Travis, myself, primarily in our family. The executive functioning tasks are the hard things. It's not the hyperactivity, and we move when we want to move and then we feel better. But it's not the hyperactivity that's the hard thing. It's all the fucking executive functioning that is the hard thing. But all that was handled. So now he's going back to school. He's like, it was so much better on tour. I'm like, I know. He's like, it was hard. I'm like, I know. And it was hot. I know. And sometimes it sucked. I know. And he's like, and I loved it. I'm like, I know. I know. You enjoyed embracing the suck. I know. This is going to inform what you do from here because you know the environment that you like. I loved playing water polo. Even when I was injured, even when I was sick, even when I got punched in the face, I loved it. It kept my day structured. And by the time I got to the end of the day, I was so fucking tired that my brain wasn't like, hey girl, hey, you've got a thing you need to do. Have you organized your photos on your iPhone lately? You should do that right now. Excuse me, it's 2 a.m. I don't give a fuck. It's 2 a.m. You should organize the photos on your phone. Why don't you make photo albums anymore? Remember when you used to make photo albums? Photo albums were awesome. Is a digital photo album really a photo album? Because you can't like feel it. So should you start printing out photos? Maybe you should hang them. Maybe you also need a photo album. Where would you even order a photo album from? Is the company that you used to get them from even still a company anymore? Because like, do people even do that? You should do that now. The fuck? I want to sleep. Please. I just want to sleep. And so Travis is having to transition into the I have to do the things, but I loved just releasing the control. And so he is in that wonderful transition, but also band is so stimulating. It's fun. It moves fast. It keeps your brain occupied. So switching back into school mode is, April said, as a former military NCO, I love my ADHD soldiers. They did so well with structure, and I knew they would have the hyper focus on the tasks I assigned them. Travis does very well in ROTC. He has not loved ROTC leadership. He has done leadership. It's not that he doesn't love his leadership. It's that he has struggled with being in leadership because other people don't just follow simple directions. And it's real fun. I'll have him come on stream at some point and share. It's real fun when he's like, ugh. I tell them they need to bring in their form. I sent them reminders that they need to bring in their forms. And then they show up and are surprised that I'm asking them for the fucking form. And then they all go, huh? What form? I've reminded you 700 times to bring in your form. It's my job to make you bring in your form. Bring in your form. Over and over and over again. I'm like, oh, so it's like herding cats? Yeah. Weird that trying to get a bunch of high school kids to do a thing that they need to do that they don't really feel motivated to do is the bane of your existence. Fun. So we're getting back into, so I feel like I have been executive functioning for both me and Travis lately, and I am very tired because I'm just like, okay, let's set a schedule. And now he's starting to do it himself. So, but movement and the rest of it. Amelia said, so he'll never be a teacher. Oh, no, never. No, wrangling other people is not his love language. George is still a little bit mad. George is still a bit mad. George the cat, for those of you that are newer to the adventures of the law nerd, George the cat is my child's soul cat. They're even the same color. And I know that doesn't make sense if you're not a cat person. There is a stream where Travis came in holding George, and Travis's hair and George's fur they are the same color. And their attitudes are fairly similar. So George will like go cuddle with Travis and be around him, and then get up, walk away, and sit with his back to him and be like, I love you, but I'm still mad at you. But I want to be around you, but I'm still mad. So there's a back and forth. But also Travis has been asleep since like Sunday. So it's also difficult. Is Fred mad at T? Fred's never mad at anybody. Fred is just like, oh, you're back. Pet me. I don't want to be pet anymore. Bye. No, Fred is just like, human. Pet me now. Goodbye. Feed me now. Goodbye. Fred does not care. Fred will manipulate all of the humans. He's like, you are here to do my bidding. George is like, but you are my person. And you were gone. And then I had to deal with these other people. Fred's just like, who does Fred prefer? Whoever's paying attention to him at the moment. Fred's just like, it's fine. Everyone loves me. Fred is the king of his own mind. And George is like, but that one's my human. And you left. Fred is just like, all of you do my bidding. Humans. I'm the superior being in this household. Pet my chin. So, yes, George is connected to Travis and was very sad, but he's getting better. It's, it's hard. So it's everybody's rebalancing. I imagine Travis is going to get home at the end of today and be asleep with food in his mouth, but we'll get there. Sina said, why is the attorney allowed to testify when the confidentiality goes beyond death? You are not the only one who asked this question. A number of you asked about the victim's attorney that is testifying. The victim's attorney that is testifying is testifying, to my understanding from the motions, and those of you that have watched the trial can fill in. I don't think it's a spoiler, but is testifying about what was going on procedurally in the divorce, not about attorney-client privileged information, but this motion was filed, this ruling was made, we were making these motions, this was difficult litigation, it was contentious litigation. Those are all things that also can be borne out in the court records, so they're not privileged, they're procedural. So hopefully that makes sense about why we will see the defense attorney testifying in that. Judy, you got this. At daughter is a high school senior. Here's to finishing strong. Cheers, Judy. Senior year, we have a million logistics to figure out because all of the photos and stuff that are supposed to happen in the summer. So now we're doing all the makeups for band photos and senior photos. And Travis is just like, somebody in my core cut my hair in I don't know, whatever state I was in. So I don't know. So he needs a haircut and sleep. But his senior photos are going to be like, oh, they're giving DCI. I need to see if I can convince him to do a senior photo with his performance shoe tan line, because damn, it's impressive. Carrie said EDB likes big binders and she cannot lie. Yeah, 100%. 100%. 100%. I don't think Sir Mix-a-Lot will ever make a song about it, but yeah, I love a big binder. I want it organized. 36, 24, 36 sounds like an index number to me. We're good. What's next does EDB Air provide? Dealer's choice, right? Or EDB Airlines provides whatever EDB is hyperfixated on. I don't know how to decide. So either dealer's choice or whatever EDB is fixated on. My personal favorite plain snack are Biscoff crackers and Cheez-Its. Either of those work on a plane for me. I can go into my very extensive thinking about plain snacks, but plain snacks can't make the fingers too sticky, can't stick in the teeth too much, and need to generally not make my mouth too dry, but need to be filling enough, but can't be crumbly. And as particularly the fingers, like the fingers are going to be hard. So those are my two favorite plain snacks, but dealer's choice. And yes, you can do champagne on a plane and Cheez-Its. Emily, do you drink champagne when you fly? No. It will give me a headache and I get motion sick. Adding alcohol to motion sickness is a giant negative Ghost Rider. And I was doing so much better. And then my hormones were like, hey, did you miss being motion sick? We're back, bitch. It's a fun phase of life. Kylie said no Cheetos on the plane. 100% no Cheetos on the plane. Sarah, has anyone had the Biscoff butter? Yes. Yeah, cookie butter is a 10-10. 10 out of 10. Music to My Soul said, Emily, that's why I asked lawyer the other day about time estimates. But Peter, how do the lawyers know? Yeah, there's people who just know. I'm not one of those people. Julie Bug said, will watching LawTube disqualify us? Not if it's a trial that's not being covered. Knowing about the law doesn't disqualify you. Being a lawyer doesn't disqualify you. Knowing a lot about the case at hand would. So if you were watching coverage of the Adelson case and got called in the Adelson case, then yes. But if you were watching cover of the Adelson case and got called in whatever, then no. So I think, honestly, people who watch cases keep more of an open mind to reasonable doubt than those who don't. Because they're like, we just need to see what the evidence is going to show. I mean, you can read some charges to me and we might go through the evidence and be like, yep. But we might go through the evidence and be like, yeah, no. I think the more trials people watch, the more it helps understand reasonable doubt for each individual. Because you see cases with very strong evidence, and then you see cases with circumstantial evidence that not everyone agrees is super strong. And then you see cases with evidence and you're all going, why are we here again? I think it helps people keep an open mind. Priya said, when are we having food court? I don't have a date yet. I haven't done laundry, and I have a huge to-do list. I have not prepped a food court because we've had so much else on the docket. So I do not know. We will see. Mamie Bell said they seem to be trying to make Donna appear more frail than she actually is. Every defense attorney ever. Look, did he let his hair go completely white for trial to look older? Defense attorneys will put their clients into some kind of a sweater vest with glasses to make them seem different. It was not my case, but it was in my courthouse, and the defense attorney was trying to cover all of the tattoos, mostly gang-affiliated tattoos of his client. And the client was not into this plan of appearing different before the jury. Like, to explain this, now the client was like, no, I want to be so for real. I want to be so for real with this jury. Like, you're not going to make me seem like who I'm not. Like, you're crushing my vibe by making me dress out in like civilian clothes. So, right ahead of trial, got new face tattoos that just could not be covered. And the defense attorney was just like, what are we doing? And he's like, we're so for real right now. Okay. They were not tattoos of the dancing girls over the eyebrow, though. So, but yes, people will. We talked about this case a little bit where the witness did not recognize the defendant because while the defendant was in custody, they had gained weight, grown out their hair, grown facial hair. And so the witness was just like, I don't know who that is. Is that supposed to be the guy? I don't know who that is. And then they brought in the booking photo, and we talked about how long it had been since the crime and the time they were in custody. And they had gained weight and grown facial hair and grown out their hair. Some people, if they have long hair, will cut their hair. People will gain weight. People will lose weight. People's appearances change in custody ahead of trial. And so it is not surprising that they will try to present Donna as more of a frail, older, sweet woman who she just loves her grandkids. She's just a grandma, you guys. I mean, she would never. Lona asked, is that on purpose? 100% it's on purpose. Perception. Human interaction. A lot of the nonverbal is based on perception. Now, the thing about humans is most trials last longer than a day or two. So, while it might be an initial perception, the jury will come to see a person day in and day out and get to know them through the evidence, and then those perceptions can start to change. That initial impression can change because we're not dealing with a 30-second interaction. We're not dealing with a 3-minute interaction. We're dealing with days and days and days and days of trial. So how effective it is, it really depends on the evidence, because I think once the jury sees and hears the evidence, and by the time they see her testify, they're going to be like, yeah. Okay. So a initial impression can be changed. And I think we will see that happen. So the Lawrences, speaking of 40, almost there. Congratulations. Jabberjay said, starting my paralegal journey Monday. Look, paralegals make the world go round. They really do. It can be stressful, but find an Alessi. Alessi has worked with his team for 30 years and gives them all of the kudos. Find someone to work with who values the people that work with them. And though lawyers can be difficult and direct, if you find someone who values your work, you will get that they're difficult and direct has nothing to do with you. If it feels like the lawyer being difficult and direct is being directed at you, that is not the right person to work for. Some lawyers are miserable to work for. Do not put up with it. Paralegals are so needed. They need you more than you need them. So you get to pick. Do not work with someone who is a dick to work with. Not at all. Not at all. Aaron said, can you be a paralegal and work from home? It depends on the area you go into. But yes, sometimes. It really depends on what kind of work you do. There are so many different kinds of work. Like a lot of the discovery companies have people who do discovery, and that would all be remote because it's all digital. So it really, really, really depends. Let's see. Nameless musician said stepson's one's a high school senior, the other is a sophomore. Both are trumpets. I'm former drumline and my partner, their mom, former color guard. It's fantastic. Look, man, Griffin chose to start playing trumpet because it was the loudest. So Griffin is in his DNA, apparently, a trumpet player because never has anything been more trumpet player. When we were in the lot after finals, two of the trumpet players who were walking out after my brain has stopped, after the lot when Cavaliers do their core song, which is Somewhere Over the Rainbow, which I don't think it's ever going to not make me cry. It's beautiful the way that they play Somewhere Over the Rainbow. But after we were in the lot and they had played Somewhere Over the Rainbow and sung their core song, they were all kind of walking to put things away and get ready for their last night with the corps and to go home on Sunday. But two of the trumpet players saw Griffin, who was standing with us, and looked at him and was like, are you going to be a Cavalier? And Griffin, because Griffin is like, why are you talking to me? Because Griffin. And he's like, well, do you want to be a Cavalier? And Griffin's like, I don't know. And I said to them, look, when he had to pick an instrument for school, he picked the trumpet because it was the loudest. And they all went, oh, you're definitely going to be a Cavalier because that is some trumpet player swagger. And then he started to smile. They started to smile. And he's like, maybe. But maybe after my brother's done. And I was like, oh, Griffin. And so when we got home, Griffin's like, maybe I should practice a bit more. And I was like, maybe you should. You'll see. And he's like, maybe I should. So it was really a fun interaction. But I love that trumpet players are just like, hey, kid, are you joining the Cavaliers? It's fun. She Speaks said, while in India, I got a chance to chat with the guy who was in the original Crusaders Corps, which won last time. Great conversation, memories, and the pride shown in their work this year. The pride really did show in their work this year. So Griffin has some George energy. Oh yeah, Griffin is Griffin. There is no other way around that Griffin will be Griffin. He is sweet and spicy. It's really fun. Chat. You are bae, law nerds. Tomorrow, because I need to stop yammering and go, there's a bunch of other work I need to do. Tomorrow, we are going to stream later than normal. I am going to figure out what we're going to do about the hearing tomorrow. And if we can't do the hearing tomorrow and need to do it on delay, I will figure that out too. I will let you know in the app. So we'll talk about it in the lounge, but I'll message all members. I will let you know in the app. I will try to post a YouTube comment. Here's the truth about my posts on YouTube. When I post on the post section of my YouTube page, like 95% of you don't even see it. And that's not on you. That's on YouTube. It just does not populate for you. It is not on you. That's why we have the app. Literally why we have the app. So I will message you. I'm going to double check the hearing for tomorrow, make sure nothing's changed, and then I will keep you posted. If it has changed, then, well, pivot. We will pivot and go from there. But we need to get, we will have Travis at some point chat with members when he is recovered a little bit to talk about his summer, and members will do some more members only videos. So we will do some more core videos because I've got some other video to share with you guys. Yay. And then I'm optimistic that we will have some exciting new tech changes. Members, you know what I'm talking about, before this trial. So yay. Brenda said, just got my notification from a members only for the unboxing last week, 5 days after the fact. I would 100% try to either re-log in or check your notification settings, because we have been having really good delivery on notifications. So something is not working the way it should. True Crime Diva said, what is the app? The Lawnard app. iOS, Android, free for you. And it is in the app stores. Let me just grab it real quick. It is in both the iOS and Android app store. So mobile app, just go to lawnardapp.com and you can download it. Again, free for you. Did I pull this one? There we go. Free for you. And I will send notifications when we have a new video and notifications when there's a change in scheduling and things like that. So get the Lawnard app. It will keep you in the loop, especially as we get into trial. We have stress tested the shit out of our app system. Lawnards have been with us while we have stress tested the entire network. We have crashed the entire network. We have done all the things. But as notifications get more complex on YouTube, the app is our reliable notification source, and we have stress tested it. We have broken it. We have rebuilt it stronger, and we have some new improvements coming to the app that will increase delivery, and on verdict days will ensure that we do not have just all of the results that we don't want. So it's getting better each time. And I love that you guys help stress test it with me. Sometimes it's real stressful on our end because we want to make sure that it's a smooth experience for y'all, but we only learn what's not working when it breaks sometimes, and then we get to make it better. So Lawnards, it's all just iterations. We break shit and then we make it better. I feel like that's my entire life story. If you've seen my TED Talk, we break shit and then we make it better. Y'all have a great rest of your day. I'll see you on stream tomorrow, time TBD. And maybe we'll learn more about this federal proctor discovery quandary, because it is quite a conundrum. And I don't really know what the solution is going to be. And I kind of love that, because normally I can see what the legal answer is and be like, I can see this being the legal answer, but the judge could do this. I have no fucking idea what's going to happen with this. This is a problem, and I'm glad I don't have to solve the problem. I can see what the problem is. I don't know where the court goes from here. We'll talk about that more tomorrow. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnard app at lawnardapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Lawnard.